Yes.
Your Lordship, with the consent from other side, I beg to mention item number 2. Your Lordship, conducting counsel Mr. N. Kumar is out session counsel from Delhi.
Wait for some time. Government has not filed any affidavit. Yes. Challenge to a rule.
Yeah.
Do you want to file or will admit it for hearing?
We have already filed.
You will file it.
Yes,
You
already
did
filed.
file.
Yes.
So we'll admit it and fix it date for hearing.
And
When will be convenient for Advocate General?
26th.
26th.
September.
26th of
Next
September.
month.
Huh?
26th.
Okay, we'll wait for some time.
May I, Lordship? I beg to mention item number 5, my Lord. The petitioner, the counsel for the petitioner, Mr. Gime Tarak is unable to attend today.
So
My Lord,
you mean 5 will take with it all these 5, 6, 7, 8,
no,
isn't it?
My lord, 7, my lord. It's a
These
connect.
are cakes, all are connected.
My lord, my lord.
5, 6, 7, 8, all are connected.
My lord.
Cases and
My lord, in 7, my lord, I have been recently I just received the paper book, my lord. I'll need to go through.
Okay,
my lord.
that is not
My
an
lord.
issue. As in,
It's a
Nikita is also here in this case.
Yes, I
Ah.
think there was not information about the attorney.
my Lord, it may be fixed for 8 on the Thursday, man.
They are inside or outside? Inside,
Yes, ma'am.
all young boys and yes. When?
8. This week, 8 of August.
8 of August?
Yes, my Lord.
Okay.
My lord.
My Lord,
Yes, give a consensus date.
after 2 weeks, 6 or 8 minutes, I think I can do it. 2 weeks.
My lord, can it be on 14, my lord?
14.
14th of August?
Yes, my lord. Because I've not seen the.
No, then,
No, no.
then make it after 15th.
After, my lord.
After 15th.
My lord.
It will take some time.
My lord, let it be after 2 weeks, my lord, because recently we received the.
Okay, okay. As agreed to by the learned counsel for the parties, list this matter after 2 weeks. We're not
Deeply.
missing any date.
My lord.
It will be now for 2 weeks.
Please, Lordship. Lordship, we are yet to receive the paper book, Lordship.
You are for
I'm for the appellant.
appellant.
Yeah.
Paper was prepared. Not yet.
Yet, no.
We have received LCR, there has been received lots.
I said this recently. To stop. Kalika, delete for paper. This appeal was admitted by this court under its order dated. What is the date of admission? 3/4/2024. Full stop. The LCR has been received. Full stop. Accordingly, registry to prepare paper book and furnish the same to the councils representing the parties and list this matter in the order column. After 3 weeks. 3 weeks, how many times it took? Paper book, almost 6 places. After 3 weeks. After 3 weeks. Deeply obliged. Admit this. You can see important issues later. Other issues like Arbitration. Hard, you are Mr.
J. Karma.
No learned counsel. Please write the names of everyone. The present appeal, present writ petition under Article 226 of the Constitution of India is preferred. Challenging the validity of Section 10 within capital A within bracket 2 small b of the Mines and Minerals within bracket Development and Regulation Act 1957 7 as amended up to date. Full stop. Admit this writ petition, issue rule, admit this writ petition. Full stop. As parties are duly represented, no formal notice need be issued. Target issue notice will be given. Formal notice need be issued. Full stop. List this matter for hearing on 26th of September 2020. More.
Line.
Yes.
My lord, as on today, my lord, I have been informed, my lord, out of 18 petitioners, my lord,
Hmm.
4 have been paid by.
Hmm.
So it is in the process, I think, payment. So, my lord, after 2
Okay.
weeks, matter,
Who is,
My lord,
who is paying?
Deputy Commissioner.
Titi Tara. Mr. Titi Tara learned.
Well, 34, whoever has submitted the documents,
No, just
34,
just
yes.
listen. Titi Tara learned counsel representing the respondent number
6.
6 submits that payment are under process and already
4 have been paid.
4 have been
No,
paid.
my lord, 38. I have the list. Just
Petitioners, I am of
Oh, no,
petitioners.
petitioners. 4 petitioners have been paid and some other, including some persons who are not the petitioners hearing. And verifications process are on and process shall be complete within a period of,
you know that
we are not saying pay, verification process. That's why within a period of
2 weeks.
2 weeks. Within a period of 2 weeks, the learned counsel for the petitioner also
Well,
submit
34,
that 4 of the petitioner have been paid and how many remain?
14 are in.
14 petitioners are yet to be paid the required compensation.
my lord, my
However, as the learned counsel, however, the process, he also agrees that processes are going on. In view of the consensus, let this matter be adjourned and be listed after 3 weeks.
my lord, my instruction is already 34 checks for 34 people have been signed, and some of the petitioners are not coming to the office.
You file an affidavit.
I'll see that because they are
You
not.
file an affidavit so that he can say no. He may say we are going, but some extraneous considerations. We are
My lord, in this case, I'm appearing for the respondent number 2, my lord. We'll be filing our counter affidavit today itself, during the course of the day. Actually,
This is appeal where, how many days delay?
322 days.
The payment, some payment.
actually,
consent order.
my lord, we are not aware of the facts of the case because we don't have any record of the matter. So just
But it
today
is-
I have taken
But
the
it is in, the judgment is, their appeal is, will support you also.
yes, my lord. That's
Then
why
why
I
are
have
you
taken
filing
the,
affidavit?
that's why, my lord, I have
What
taken the
about
copy
what
of
about
the
the
writ
petitioner?
today.
Where is the writ petitioner? Will condone the delay.
On
Some other appeals were also there regarding similar situations. What happened to those? That issue. There are similar orders like this, non-payment of bills.
I'm not aware about it. My lord, let it be taken up on next Monday, my lord, because
You are nobody.
I am representing
You are
a department,
nobody
my
to
lord.
object
Let
this.
my affidavit be filed today, my lord. That is the thing, my lord.
You are nobody to object this.
No.
You are a respondent in the writ petition.
I think we are of the same side.
You are in the same side.
That may be recorded.
Okay. Hard. Mr. I always forget your name. Okay. Learned State Council. The present application under Section 5 of the Limitation Act, don't write Section 5. No Section 5 is applicable in writ appeal. The present application is filed. Writ appeal is filed. So application is filed for condonation with a prayer to condone delay of 322 days in filing the appeal petition. against the judgment and order dated 9/5/2023 passed in what IAC? Main case is ISC number 79 within bracket AP/2023. Where is that order?
Order is a page lordship 11 and 9 lordship.
Page
9
page 9 of the IA.
IL annexure 1.
What happened to the main writ petition?
Lordship main writ petition was already disposed of.
Then,
Whereby lordship the estate has been directed
Hmm.
to pay the lordship admitted pending dues.
Ah.
Thereafter, one observation has been made. If that's not paid within 6 months, then the petitioner will be entitled for claiming interest before the approved forum. That has to be forum. Thereafter, lordship the petitioner filed another IA, this IA,
Hmm.
whereby he claimed for the lordship interest.
this is the interest.
This is the interest part also.
Where is the objection has been filed? Where is the petitioner?
Now, last occasion also petition was not present. Today also.
Full stop. Full stop. None appear for none represented. No. There is a mistake in the last order. Okay, none appears for, we are just, since objection is filed
No.
by the petitioner,
It's correct.
file, we'll give a chance next Wednesday we are taking it up.
No issue.
You are here,
Extremely sorry for the petitioner.
we'll condone the delay. Okay, we are fixing it on Wednesday, come prepared.
Next Wednesday,
Next, this Wednesday,
this
day
Wednesday.
after tomorrow. Yeah.
Okay, madam. I'll be attending through online.
Okay, no problem. Welcome. The learned counsel for the respondent writ petitioner prays for some accommodation today. Mr. Prayer is allowed. Raise this matter on Wednesday. Tuesday and Friday. So we can sit on Thursday and Friday. Thursday. Oh. Okay, then we'll do the Tuesday and Thursday. Okay, Thursday. That's why we keep things done. Yes. Okay. Right.
Obliged, ma'am.
Eight.
Item 33.
Yes, my
It is
lordship.
hearing matters. These are basically all together, is not it?
My lordship, we are going to file a
File.
connected matter today. So if both are listed tomorrow, so it will be convenient for both the.
We'll hear this and dispose it of, then you have tomorrow, we'll have to withdraw this that petition.
No, no, no.
Or
It won't be like this.
oh. Yes,
So-
Nikita, this is your matter or what? No.
No,
Okay.
it's I'm on.
Okay, list this matter tomorrow. On the
Deeply
prayer of
obliged.
the learned counsel for the petitioner, list this matter tomorrow.
Deeply obliged. May I lordship, beg to mention item number 24, my lord.
Item number?
24.
Yes.
About a respondent. I'm on behalf of G. Tarak.
Why this matter is listed today?
No, I don't
Oh,
know.
no, wait for something. These are the orders matters, steps, these, that, we'll see. Orders don't seek adjournment, will adjourn when the matter lists. Okay?
Oh, bless me.
Yes.
May I please, ma'am? My lord, I beg to mention item number 32, madam.
Item number
32, madam.
32.
Yes, ma'am.
Yes.
Since the leading counsel, Deep Angin is out of station, madam. Matter may be,
Anything survives?
yes, madam.
Huh?
Yes, ma'am.
When?
After a week, madam.
On the prayer of the learned counsel for the petitioner, list this matter after 2 weeks.
Obliged.
May I please, my lord?
Yes.
My lord, this is an election petition. It has come for the first time.
Okay.
So there's only one respondent, my lord.
Only one respondent.
Only one respondent, my lord. The written candidate. So if your lordship please notice my kindly issue so it can be heard.
Heard Mr. Gunadhar Singh, Gunadhar Singh, learned counsel for the petitioner. Full stop. The present petition is election petition is filed under section 80, read with section 81, 81, 80 capital A, 81, 100 and 101 of the Representation of People's Act 1951, challenging the election of respondent 3, challenging the election of the sole respondent as a member of 11th Arunachal Pradesh Legislative Assembly election 2024 from 9 Sayang, correct those absolutely look into CHAYNG Sayang Tajo within bracket ST Assembly constituency. Issue summon to the respondent. Summon be issued through registered post. Steps for issuance of summons be taken with registered post with AD. Such steps to be taken within 2 working days from today. Full stop. Thusly, Mr. Singh, learned counsel, also praised that he may be permitted to take steps through the ST. Full stop. Prayer is allowed. The ST step is permitted to be taken upon the sole respondent. However, such notice, such summon should be routed through registry of this court. Full stop. The next date of the case is fixed on 16th of August 2024.
16 of August.
Can you?
Okay.
So that we can see, you can take steps, Dusty.
My
You
lord.
can pass an order.
My lord, if your lord says, my lord, it's okay, my lord. I'll try to be better than 60. Because I got a short notice yesterday, so I could have come appear physically, my lord. And now I'm in Fal. I got only in the evening yesterday.
No, not these days. Initially, you need not. Tell us a date because we'll have to complete within a period.
My lord, it's okay, 16, my lord.
Hmm?
16 is okay, 16 is okay.
2 weeks. Ultimately, maybe next date, maybe virtual also. Give it on.
My lord, if your lordship is pleased, my lord.
Give it on. Yeah. Twenty-third of August. 20.
My lord, 16, my lord, I'll try to come on 16. Let it be on 16, my lord. I'll do the necessary things. Yes, your
No,
lordship.
for the stage, because Dusty then return notice.
Yeah,
everything.
that is
That's
also
why
true.
that's why we're fixing on 23rd.
My lord, my lord.
List this matter on 23rd of August 2024. The next date of the case is clearly to be reflected in the summon accompanying the dusty service. Notice accompanying the dusty service. Full stop. Prior to the next date fix, the petitioner shall file an affidavit in proof of such dusty service. Full stop. List accordingly.
Obliged, my lord.
Good morning, my lord.
Yes, you are Mr.
Yeah, Nyasam Johnson.
Heard. Mr. Nyasam
Johnson.
Jongsam.
Yeah.
NYASAM JONGSAM.
Yeah.
Full stop. How many respondents?
Respondent 3.
3.
3 respondents.
The present election petition, the petitioner in person.
Yeah.
The present election petition is filed under section 80 and 81 of the Representations of People Act 1951, questioning the election of respondent number 1 to the Legislative Assembly of Arunachal Pradesh from number 53 Sanglang North within bracket ST Assembly constituency. The rest will be same. We are fixing next date on 23rd
23rd.
of August 2024. You will have to take steps. Order, everything will be reflected.
Okay.
You will have to take steps and through Dusty also.
Yeah.
So that you can serve personally and file an affidavit.
Okay.
And you'll have to file the affidavit before the next date.
Okay.
Okay.
Yeah.
And steps through registered post is to be taken within 2 working days from today.
Yeah. Okay.
And if present situation continues, then on 23rd, you will have to do this through virtual mode.
Okay.
Okay.
I oblige you.
You will have to do it virtual mode. We'll get the order by second half on online. You do accordingly.
I oblige.
May I
Yes.
please, Lordship?
Hmm.
Lordship, this is a contempt application
Hmm.
filed by the petitioner.
Yes, what was the direction?
Lordship, page number 13.
Yes.
Lordship,
Page number
13.
13.
Yes, Lordship. Lordship, the petitioner has filed a writ petition.
No, operative portion. What was your writ petition?
Lordship, regarding in this writ petition, clear and specific direction has been given to the respondent number 2 and 3. The operative portion is at page number 25. 25. Accordingly, we remand back to the Director, Rural Development Department to undertake the exercise for approval of recommendation made by the Project Director, DRDA Kurunkume District. In respect of the tender NIT dated 21/8/2023 for procurement of material pertaining to MG Narega Works 2023-24 for CD Block Polosang. Under package number so and so, the exercise shall be carried within 2 weeks from
Where is that order dated 8/1/2024?
Lordship, that is in the main writ petition, which I have not annexed.
This is very vital. What was set aside, we must understand in the contempt.
Lo-
What was the contents of that
That is regarding the issue of letter of intent, which was
letter of intent was issued to the private respondent?
Lordship. Letter of
That-
intent was issued to the private
That
respondent.
was set aside. Now,
Yes,
and it was remanded back to take a fresh decision.
Lordship.
Now what happened, Director?
Lordship, page number 26. So Lordship, the copy of this judgment and order was communicated and supplied to the respondent in this.
When? It was, what is the date of the order? It was on 21st of May, is that it?
Lordship.
21st of May, Secretary received it.
Yes, Lordship. So
Now,
after,
what is the date of this order?
date of this order is Lordship,
24/5.
Lordship, 24/5.
24/5/2024. This order was passed.
Lordship,
On 31st of May, you submitted it.
Lordship.
Before whom?
Before, before the opposite party,
Now, then
despite of receipt of this
notice.
judgment
Then
and
they
order.
issued this order 21st of June.
Lordship,
This is your case.
yes, yes.
Now,
Violating,
21st June is a letter of intent.
yes, Lordship.
So where do we find that they have not exercised this power? Because it will mean necessarily 21st of June 2024 will show that earlier letter of intent 8/1/2004 was not acted upon.
Lordship,
So that part of the judgment is complied with.
Lordship,
Now what remains is director was given to take a fresh exercise.
yes. And no,
For approval of the recommendation made by the project director.
Lordship,
Now, what was the recommendation of the project director?
Lord, recommendation,
How do you know that this was the recommendation, this has not been complied with?
recommendation of project
No,
director
from
was,
where do I know that?
Lordship. I'll make a necessary amendment if required, Lordship.
So you'll have to see, contempt is a quasi-criminal, yes.
My lord, I am the standing counsel, my lord, here of the department, my lord. What happened, my lord, they have filed a writ petition where entry was also vacated, my lord. After
Now that we
considering,
understand, order was that earlier letter of intent issued to somebody,
Yes,
maybe
yes.
the same person, it
Yes.
was set aside.
yes,
Then thereafter, it was remanded back
remanded back.
consider an approval. What, this case might be a case that it was considered and fresh and
Yes, yes, ma'am.
intent was issued.
Yes, ma'am, yes.
Therefore, to prima facie have a satisfaction of contempt, you will have to show that approval, then also contempt is not there. You will have to challenge this order of letter of intent afresh.
Lordship.
My lord, they have filed a writ petition, my lord.
They
That
have filed a writ
Yes,
petition.
my lord, the entry was also vacated, my lord.
In subsequent to this.
Yes, my lord.
that is different case, Lordship. That is different.
Same issue, my lord.
But-
Same.
No. This 21st of June 2024 letter of intent, was it challenged?
Yes, my lord.
Yes, Lordship, it was challenged.
Which writ petition?
Writ petition number 51/24.
List this matter along with
Madam.
WPC 51 of
Madam.
2024. Stop. In the meantime, the learned counsel for the petitioner may file additional affidavit to bring necessary facts for on record for determination of this
Lord.
contempt petition. First of list this matter Friday.
Okay, deeply obliged.
These are essential.
Okay.
My lordship.
Lordship, in this writ petition, my lord, we are challenging the action of the respondent number 3, my lord.
Hmm.
Your lordship will see, my lord, in annexure 1, lordship.
Yes.
the petitioner, sorry, petitioner, annexure to page 19, Lordship.
Page 19.
Yes. The petitioner, she has the land possession certificate, my lord, which is the
Now that we understand, now what is the present status of the land?
now, my lord, without affording any opportunity of being heard, my lord, even the license is there, Lordship will see
No, no, we
annexure.
have seen that. We
Yes.
suppose for the time being,
Yes.
we accept everything.
Yes,
Will issue a notice?
yes, Lordship.
You don't have any prayer for interim.
No, but no, there's no use of praying any interim now. They
No.
have evicted everything, my lord.
But what will happen to suppose there is a building tomorrow? So you have no problem in acquiring the land and doing
No,
something?
they are not acquiring, my lord. They just want to, my lord, dismantle. They said you cannot construct the tourist, that one houses there. Man. That's the only, it's my
Okay.
land, man.
That is that the only, so they
Yes.
are not on the land,
No,
on the building only.
yes.
Okay, heard. Learned counsel for the petitioner, heard Mr. Learned counsel for the R. Sona, Rajesh Sona, learned counsel for the petitioner. The grievance of the petitioner is that the building of a building
Yes, sir.
of the petitioner. A building constructed by the petitioner over his private land
Yes, Lordship.
has been demolished
Yes.
by the authorities without following due process of law or without there being any allegation of any illegal
Yes,
construction. Full stop. Accordingly, the present writ petition is filed seeking remedy as well as compensation
Yes.
against the state respondents for their activities. First up, issue notice returnable after 4 weeks.
4 weeks.
Returnable after 4 weeks. Your MS Pramuk accepts notice on behalf of all the respondents.
Yes, sir.
All the respondents as respondents are duly represented through the learned government advocate. No formal notice need be issued. Full stop. However, extra copies of the
Yes, sir.
writ petition, requisite in numbers be furnished to the learned state council within a period of 3 days from today.
Obliged, Lordship.
Yes.
Your Honor, in post title, there is some mistake, so I may be
What is
allowed
the
to
mistake?
withdraw. In the respondent number 4, the Commissioner, Department of Labor and Employment, Government of Arunachal Pradesh. I have to supposed to make that the Department of Agriculture.
Now, what do you want to correct it?
Yes, Your Honor.
Which you want to correct it?
Respondent number 4,
Page
7,
page 7.
in the post title.
An appointment we made like this way. Huh?
Yes, Your Honor, can you see the page number?
Page number? First title, where is which we want to correct?
Page number 7,
Page number 7.
respondent number 4,
Page number 7.
page number 4.
Just a minute. Page number 7, respondent number 4 should be
That is Department of Agriculture.
so you want to delete the commissioner.
Yes.
Learned counsel for the petitioner submits that instead of arraying the Department of Labor and Employment, Government of Arunachal Pradesh, Itanagar, represented through its commissioner, the petitioner has inadvertently arrayed the commissioner himself as the respondent number 4. Therefore, he prays for correction of the cause title. Prayer is allowed. The petitioner is prayer is allowed. Petitioner is permitted to correct the cost title by furnishing a fresh cost title before the registry in terms of the extent norms. Full stop. List this matter in the motion column again on Wednesday, Friday. In the meantime, you have to give a fresh cost title to them and everybody.
May I please, madam?
Yes.
Madam, by the impugn NIT, my lord,
Hmm.
has been issued, my lord,
Hmm.
issued a fine at page.
What is the challenge in this petition?
I am challenging the, my lord, one clause in the NIT, my lord, whereby, my lord, NIT has been floated, my lord, at page 104, my lord,
Page
104, my lord.
104.
Yes. This is subsequent NIT, my lord.
Hmm.
After cancelling my termination, my lord.
Risk and
After
cost.
terminating me, my lord.
Risk and cost.
Risk and cost, my
That
lord.
is a natural process.
My lord, how they have arrived, my lord?
How they have a right is to be determined in either arbitration or civil suit,
My lord,
whichever is permitted.
my lord.
It's a contract, private contract between you and FCI. They have terminated your contract. They say that it is a risk and cost. It will be a risk and cost because the excess payment you will have to make. You file a
My lord,
arbitration.
in the, my lord, termination of the contract,
Hmm.
that aspect was not mentioned, my lord. Only said that, my lord.
That is not necessary.
My lord, they have itself by
Take
letter
your
dated 10.
Take your seat. We'll hear you when it's necessary. Yes.
Then, my lord, if my lord's view is there, my lord,
No,
then, my lord,
our views are, it should be based on law. If you
Yeah.
can say that no, Lordship's view is absolutely not based on law, I'll have to change my views. We are not monarch to decide that this is my view, so therefore I like it, I will dislike it. No.
then one
My
aspect
view
is
is,
that, my lord.
according to me, it's based on law, principle of law. That
Another aspect, my
first
lord.
of all is tender contract cannot be interfered in this manner until and unless it's discriminatory or in such a situation that it is to exclude or with malafide intention or to benefit somebody. This is number one. Number two, in your case, this risk and cost clause arises out of an earlier contract.
Yes.
Always. Because that contract you are supposed to execute it. I have not seen the file, but risk when it is risk and cost, that will imply that you had the earlier, somebody was executing the work, this was not completed, and therefore it was terminated. Work is to be completed, a fresh tender is given. Work is complete?
Work is, my lord, almost completed, my lord.
Almost completed. You will have your remedy to seek an arbitration that your termination itself is wrong. Give me loss of profit. I have started work.
No, my lord, I'm not against the termination of my contract, my lord. It's because, my lord,
Oh, then too you have no case.
my lord, because, my lord,
Then you don't have any case.
my lord, my
If
lord,
you are not agreed by the termination, that will obviously be on risk and
I
cost.
only agree by, my lord, only this part, my lord.
You cannot be.
Because, my lord, the manner in which, my lord, terminated, my lord, in fact, my lord, they have issued the acceptance letter, my lord, and I have requested, it was, my lord, during the COVID period, my lord.
Understand. You say that I withdrew from this contract because I cannot do.
Yes, ma'am.
In the contract itself, there will be a provision of validity of bid period. There will be provision that once you accept, you cannot do this, you cannot do that. I think your money has already been forfeited.
No.
Security
He is
deposit.
MSME, my lord. So
Huh?
no MD was also deposited because he is a MSME registered, my lord.
ST,
That's why he has
scheduled tribe lady, my
Yeah,
lord, that's
from-
why it is exempted, my lord.
So exempted is exempted. We cannot say interfere with this clause.
Because, my lord, one of the, my lord, conditions of the, my lord, tender manual, my lord, is that, my lord, the first, before my lord acceptance
Okay,
of the,
okay, understand. Now tell us what are your grounds for challenging that contract?
my ground is,
Legally
my lord,
sustainable ground. You cannot
My
say
lord,
that I am a
then my
private
lord-
entity, therefore I am helpless. No.
my
You
lord,
you have entered into a contract, if you could not execute, tell us, what are your good grounds?
my lord, kindly see the first one acceptance letter, my lord. Is page 74, my lord.
Yes,
74, my lord.
yes.
Asking me to deposit the security amounts, my lord.
Hmm.
And my lord, lordship, next page, my lord. Last paragraph, my lord. Further, the letter of appointment to the
Which
contractor,
page 74?
74 is the acceptance letter, my lord,
Huh?
asking deposits
Hmm.
of the security deposits, my lord.
Hmm.
And page 75, my lord, last paragraph, my lord. May I read, my lord? Further, the letter of appointment to the contractor will be issued.
What is
only-
the risk and cost, any condition in the
I
original
will
contract?
come to this.
Yes, my lord, it is in the
Just-
page 52, my lord.
Yes, 52, no? Okay. Okay, yes, sir. So, yeah, you proceed, yes.
Well, may I read, my lord?
Hmm.
The further, the appointment to the contractor will be issued only after fulfilling this requirement and the confirmation of the bank guarantees.
Hmm.
These instructions are without prejudice to any other terms and condition of the MTF.
Okay,
Well, meaning thereby, my lord, my acceptance will be further be preceded by an appointment of the contract, my lord. And my this letter was, my lord, covered. These are all by email, my lord. And cover letter of the email is at page 76, my lord.
what is the contract signed by both of them?
Yes, my lord, that is MTF. It starts from page 42, my lord.
Oh, this is tender.
My lord,
Yes.
what they are saying that, my lord,
42.
my tender bid documents
Hmm.
is the contract, my lord, they are saying, my lord. There is
Where,
no,
from where are you saying?
they are saying, my lord, because my, there is no agreement, my lord, pursuant to the, my lord, acceptance also, my lord. Saying that, my lord, these are the, my lord,
So
Part-
according to you, a contract did not even
yes,
was signed,
yes, yes, my lord.
and therefore I cannot be fastened with risk and cost.
Yes, ma'am.
This is your case.
Yes.
Be precise. You cannot say I am helpless, COVID. So their case is that tender document itself is a contract. There is no separate contract is required. Show us from there.
Their signature is there.
Now, her signature is there. Let us see from this contract.
That risk and cost factor.
But not on risk and cost factor, then see.
My lord, one of the another condition, my lord, in the cover letter of the, my lord, the email, lord, should kindly see for a moment, the page 76, my lord.
Yes.
76.
Just a minute. Give some important dates.
This, my lord. My lord, the
Give
NIT
some-
was
give- Give some important dates. When the
NIT
NIT was issued,
17/6/2021, my lord.
17/6,
2021, my lord.
2021. Are we going for final disposal?
My lord.
Yes.
Tell us.
My lord.
No
My lord.
halfway business midway.
My lord, if
We-
they,
we
if they
Just-
produces the requested documents, my lord.
Huh?
If they produces the original documents, my lord.
Huh.
It is up to them, my lord. Because I cannot produce them, my lord.
Which
Original-
original document?
The original documents which has been submitted, the beach documents which has been
Nobody is
submitted.
disputing any document here.
No, my lord.
Are you disputing any
No,
of their
no, no.
documents?
How it proceed, my lord? The initially, it's a e-procurement, my lord. E-procurement said they have to submit their documents, my lord, through net, my lord, internet, my lord. So after the letter of acceptance was issued, he was asked to deposit, security deposit and the bank guarantee. Then he refused that I am unable to deposit the
So therefore, the fundamental thing is that how the procedure, how the contract is to signed. That is what
Yes,
we want.
after when the letter of that letter of
So,
appointment will be
do you
issued after
say
the
that
depositing the
we-
SD and
You want to propose, say, so is it a case that there was a tender? He participated, he or she whatsoever, selected for contract. Isn't it?
yes, my lord.
Selected for contract. Now thereafter, letter of acceptance was issued.
Yes, my lord.
At that point of time, she refused to sign the contract.
My lord, our MTF is itself the contract, my lord.
We'll come to that.
Yes, my lord.
So according to you, there is no provision of signing any fresh contract.
Yes, my lord.
And the contract will sign from the date of
Submitting.
from the date of submission of the tender. Show us that from your tender document. That this is a contract.
It may be taken after some time, my lord. I will show it.
No, after some time. Let us see. This is the vital issue. Okay. This is the vital issue.
Now, I have got his point now that
Huh?
he mean to say that this is not a contract.
Yeah, of course, if this is his case, that how can tender be a contract? I have not accepted that tender. Where is the risk and cost of my loss?
That is, my lord, at page
No,
52 of
Take your time, go through it, we'll
Yes.
come back to it.
Yes.
Yes, next, yes.
My lord, this case can be disposed of today because the lawyer has also come all the way from Guwahati or tomorrow. But instead respondent has filed their affidavit. The defense instead has filed their affidavit.
No, let's just tell us, what is the stand of the revenue authority in state of Arunachal?
My lord, they are the one, they are the acquiring and the government has authorizes the deputy commissioner to
No,
undertake.
this is army land, isn't it?
Yes, madam.
Army.
Yes.
So your whole case is that without any process semblance of any land acquisition.
Yes.
They have taken our land
Initially. madam.
initially, saying that there may be some hiring charges, this, that, but that continues as it is.
Continued.
Then after many years you file. Now they take a stand that there are some land acquisition process. You say that there is something they want to say, but that cannot be a land acquisition process.
The complete process has
Complete
not been
process,
followed.
complete
No
process.
compensation
Now,
paid.
what is the specific stand of the government as regard how they have, whether three issues, whether this land is a private land. Number one, how it was handed over to the army. And if it is handed over to the army, whether the law relevant at that point of time or any at subsequent period, any process has been initiated or any compensation has been given. What
Lordship,
is your stand?
Lordship, in this, in our affidavit, we have stated that there is no record of acquiring the land or paying any compensation. And thereafter, Lordship, by order of this honorable court, we have also repeatedly sent to
Okay, according to you, there is no land. About
there is no record, Lordship.
about the status of this land.
So, Lordship, as per this, if there is a direction with the approval of government, we have to acquire the lands.
That we know.
No, this is the lane.
No, what is the stand of the revenue authority? Land belongs to whom, according to you?
Lord belongs to, Lordship belongs to the petitioners, Lordship.
Have you taken specific stand? In which paragraph? These are very vital issues. We need not go through all this from 1947. Two ways into look into. If government, the revenue authority clarifies that this is a land belonging to so-and-so, and this land was never acquired, no payment of compensation has been made, then it will be a different order. And if government says, no, this is not a land, or at the same time, if the armed forces can show that no, there was a land acquisition process, we have not taken over this land, or our government has gifted us, or somebody has done it. So what is the stand?
Lordship,
We cannot allow you to do your homework here.
Lordship,
This will be
page
the point.
11, Lordship.
Huh?
Page 11 of our affidavit,
Tell us. We believe the lawyers.
that with regard to statement made in FERA 19 and 20 of the answering respondent neither admits or denies. However, no record of land acquisition of the land in question are available
Okay,
in the
fine. Land acquisition fine. Ownership.
the whole land in question falls within the jurisdiction of Tupen Village Council Land Management Commission, and same is reflected in the Joint Survey Report 2002 to 2003. Lordship.
What the joint survey report says? What is the highlighted point of joint survey report? Yes, armed forces. What is your state? Huh?
And for the
Ministry of Defense.
Defense.
Yes, what is your state? Come.
We filed our affidavit on last occasion,
Hmm.
and as per my senior instruction, matter may be fixed for hearing, my lord. Or next
Letter maybe?
fixed for hearing. Pleadings are complete, my lord.
Okay, we are hearing it.
Next date, my lord.
We are hearing it.
So that my senior may appear, my lord.
Who is your senior?
Why Dolly, my lord?
When will he appear?
Day after tomorrow, my lord, on 8th, my lord.
Now tell us, what is your case?
Actually, I'm not authorized.
You are not aware. Yes, what is the state? Army state?
My lord, they are claiming that the land was acquired and they have annexed certain documents. And we have also, because this has been going on since 1978. So we have also filed in some other, they have also claiming that they have acquired this. And they have annexed certain documents. And I have annexed all those documents in my writ petitions, claiming that those are only notification under section 4 and 6 and 7. That's all.
Show me a sample of the notification.
But you also may kindly come to my writ petition.
Which petition?
Item number
WPC?
WPC 187 or 188, 86, all the same. Madam.
WPC? 187.
187 or 186, any
Yes, I have taken.
187.
Yes, tell us. Yes.
You know, may kindly come to page 58 onwards.
58. Army's affidavit.
No, madam, my writ petition.
No. We want to go to the army.
Oh,
state.
yes, madam.
To us armed forces. Yes,
Madam,
when can
page
the senior come tell us?
158, my lord.
Huh?
158.
158.
158. But my lord, before this, if we can take up my writ petitions where
No, we'll take.
Yes,
See, we are not doing final hearing. He is helpless today.
okay.
But we understand if we
Yes,
hear in this week, we're spending some time.
My lord,
so
yes. My lord, their stand is that Annexure 158, one of the documents they are relying.
There is no
158, my lord, Annexure 1.
After 99, there is no pagination. Okay, tell us a date.
No, my lord, this is dated 18 September 1971.
This is commissioner, this is filed by Mickey.
No, my lord, this is by the government. This is by the defense state.
What is the defense affidavit? Yes, 64. Affidavits are kept in separate files or what? Huh? Affidavit of
The defense state, my lord.
page
1, 3, and 4.
1,
Let's make 1, 3, and 4.
180,
158, my lord.
158.
8.
Just a minute. Okay.
Now, my lord, this is one document which they are relying. And my responsible submission is this is only a sanction order. That is basically the in principle approval. It says I am directed to convey the sanction of the president to the acquisition of such and such in such and such at the estimated cost of such and such, including my lord. And then my lord, here one thing is my lord, they have already determined the amount also. This determination of amount itself is not as per law, because a determination of the amount will be done by the revenue officer. under section 9.
No, it was taken in 1971.
This is only conveying a sanction order to go for
Sanction order.
to go
And
for
land was acquired when?
now they
According to
are
army, when it was.
now my lord, they are referring to page 164.
Yes.
This is 29 April 1972. You also may come to clause 2. This notification made under the provision of section 4 of the Land Acquisition Act, such and such, my lord. Section 4 is the first preliminary notification.
This is section 4 notification.
Yes.
Then
That,
under section 4, then what happened?
then, my lord,
Any award passed?
no award was passed, but no hearing under section 5A. Then
No, you want to say after this section 4, no subsequent notice under section 6 was issued.
no notice under section 5A.
5A.
And they have shown a notification, common notification under section 6 and 7
This matter will require some hearing. When?
on 8.
Make it sure.
Because before that, my lord, if I take your lordship to my writ petition, because there, there still has been clearly mentioned there.
Which are the relevant acts that will be required? In
Earlier it was under Land Acquisition Act 1894, and presently, since if your lordship finds that this has not been acquired, and if they are ready to acquire, then it will be under LARA 2013. As per law, my lord, whatever. So on 8, my lord.
Okay, 8 is a Friday?
Thursday.
Thursday.
Okay.
You are Mr.
S.Z. Rahman.
Huh?
S.Z. Rahman.
S.J. Rahman.
Appearing on web Y. Dolim.
Learned counsel appearing on behalf of Mr. Y. Doloy. Learned counsel representing the
1, 3, and 4.
respondent number 1, 3, and 4. Praise for an adjournment on behalf of Mr. Doloy. And praise that matter may be fixed on 8th of August 2024. Prayer is not opposed by the learned counsel for the petitioners. List accordingly. And state, you take your position clear. What is your position? And have you filed any reply to the Army's affidavit? What will be your stand on Army's affidavit and this section 4 notification? This will be vital issues.
I have filed my reply.
You have filed.
Yes.
No, but what is the state stand? Because ultimately,
They are
assuming for a moment that section 4 notice is there, it can be issued by whom? Whose signature is this in this notice?
Yes. In fact, I have raised this issue, my lord. When these documents are not available in the government of Arunachal Pradesh, not in the deputy commissioner.
To Army, who issued this notification?
These are documents produced by the army.
Author of that section 4 notice, I just missed it.
By the allegedly by the secretary.
Secretary of?
Secretary to the government land management, land department, government of Arunachal Pradesh. That time Union Territory, my lord.
Okay. So we'll have to travel to history in this case.
Yes, my lord.
Okay, or we'll admit and fix it for hearing. Then it will be in the last in the list.
No, let it be on an admission stage only.
But we'll take up after the list is over. Okay.
Hello.
But Thursday there will be a division bench also.
Then Wednesday, my lord.
Wednesday?
So my CA is coming on day after tomorrow night.
Day after tomorrow?
Day after tomorrow night.
That is Wednesday.
Wednesday?
7.
Today is Monday.
Okay, on Monday actually.
Today is Monday. Have a consultation with your senior and give that day.
Okay.
Either 7 or 8.
Huh?
Either 7 or 8.
Third day is what you say. There will be a division bench on Thursday.
Let it be on Wednesday, my lord. 7.
Or if not, then on 12th. If not, on 12th. We'll prefer it to be on 7th or 8th, if, okay, 7th or 8th. Okay.
My lord.
Give a date to my secretary. Yes.
Obliged, my lord.
May I plead, my lord?
Just 1 minute. Other RLFS. What is the stand of the armed forces as regards the state?
My lord, this is under Ministry of Defense, but land acquisition is dealt by the defense state.
No, that is fine. Lands are different state. The question is, what is your stand against stand regarding the state's position? State says that yes, this land belongs to so and so, so and so.
No, they have not questioned that.
They
have not questioned.
Only issue is whether there was a land acquisition or not.
Properly done or not,
Or
that's
not.
all.
Okay. Suppose a land acquisition is, suppose we assume that the land acquisition as projected by the defense state is a land acquisition.
Yes.
Then matter ends.
Then matter ends.
Matter ends.
Matter ends.
If we so that yes, there was an award, and if we say that no land acquisition compensation, land acquisition due process was not followed, then what should be the order?
Now.
You have some authorities on that.
Yes, my lord, I have brought that Supreme
What
Court.
should be the authority?
Yes.
Yes.
May I plead?
Yes.
Your Lordship, my
But
lord?
this item
My lord, this
number
matter is related to
Item number?
basically,
12.
yes, my lord. Basically the domestic issues, domestic violence, and then the issue of extramarital issues, my lord.
Yes, everybody represented.
I'm for respondent number 2 and 3.
How many respondents are there?
There are 4.
We are 2 and 3.
I'm for respondent number 4.
4 and what? 1? 1. Now what to be done today?
My lord, matter
Tell
can be,
us. We are ready.
matter can be hard and dispose of, my lord.
Hard and disposal. Okay.
I have only not much submission in this matter, my lord.
Interim order is there. We have dealt with it.
Yes, interim order is there, my lord.
Yes.
Yes, my
So
lord.
basic issue is that having no jurisdiction to
Yes, my lord. My lord,
Let's see the
this is one. Another is that same matter has been disposed of by the National Women Commission, NCW.
same matter.
Same matter.
Where is that?
My lord,
Just let us understand the facts. First.
yes, my lord. The fact is that
What
present,
is yours then?
My stand, I'm relying on a citation,
Of
which is in my favor.
okay. Okay, let us first understand the issues, then
Yes,
we'll
my
go to
lord.
the authority. Yes.
my lord, fact, my lord, is that the petitioner number 1 is having at 11 a.m. it came to the notice of the commission that the matter regarding the marital cruelty has already been decided by the court. Husband has informed that he has also filed a divorce petition in the court. The commission did not receive any information on any court cases.
Has already been decided by court means?
Yes, my lord. Decided by the
During
court.
the hearing on 29/5/2011, it came to the notice of the commission that the matter regarding marital cruelty has already been decided by the court.
Means I think they wanted to say that they have filed a case before the court, I think maybe, my lord.
No, this is the order, isn't it? This is the order.
Because the divorce
The
petition.
husband has informed that he has also filed a divorce petition in the court. The commission did not receive any information on any court case with the original complaint registered as case number. What is this?
My lord, there is 2 complaint, my lord. The complainant, respondent number 5 has has filed 2 or 3 complaint, my lord. One complaint was before the.
Just give me a minute.
Yes, my lord. One was before the under the Domestic Violence Act, my lord. Before the Judicial Magistrate First Class, UPR.
These three petitioners are, who are they?
Rest are, one is the daughter of number 1, 2 and 3.
No, how they are, all these three are related to the four, respondent number 4?
Because there is a notice
They are in-laws.
against
They are in-laws.
yes,
They
in-law.
are in-laws of respondent number 4.
No, they are not in-law, my lord. They are mother and father of petition number 1.
Mother and father of the petition
Petition
number
number
1. So complicated.
Yes, they have alleged that the petitioner's family has tried to
Let us see the first complaint lodged on the basis of which the or the impugn or order was passed.
my lord, there is 2-3 complaint, my lord. I will just take to first complaint, my lord, maybe
No, the lady went to the commission,
commission, my lord.
state commission.
Commission.
Let us see the complaint.
Yes, my lord. My lord, it's a page 20, my lord.
Page
20.
20.
20. Against the
20.
yes, my lord.
Yes.
Complaint dated 28/04/2023. The complaint was addressed to the chairperson, Arunachal Pradesh State Commission for Women. Subject complaint against such person. A complaint was against the petitioner number 1, petitioner number 2. Petitioner 2 is the father of the petitioner number 1, and then Srimati Yape Chisi is the mother of the petitioner number 1. For a mental harassment, emotional abuse, extramarital affair, and requesting APSCW to book them under appropriate section of the law. So this was the file. This complaint was filed, and your lordship may see against the person they have filed is page 24.
Just a minute. So allegation is against basically Jimmy.
Yes.
Okay.
Allegation is basically Jimmy. So my lord, may
And
see.
these are relatives of Jimmy. The petitioners.
Petitioners are yes. Alleged
Relatives
to
of
be
Jimmy.
relatives to
Let us not go to so details. Who
Yes,
then
my
we
lord.
get confused.
Yes, madam.
So it's a clash between Jimmy and Shrine.
Yes.
Huh?
Yes.
And the petitioners here are relatives of
The respondent number 4's husband, Jimmy.
respondent number 4's husband.
Jimmy.
That is
Because
now who is the third pillar between Jimmy and Shrine?
is the respondent number 1.
What is the name?
So petition number 1.
Petitioner number 1.
Karpuchisi.
This is the third pillar.
Third pillar.
In
That
between.
is the allied.
Okay, what is the name?
Karpuchisi.
He is the petitioner number 1.
1, yes.
Kaku?
Karpuchisi.
Kapu.
Karpuchisi.
Kapu. Kapu is a lady.
Yes, my lord.
So you are the relatives, others are relatives of Kapu. Isn't it?
Yes.
Okay, this is the complaint.
Yes.
Forget about the details of the complaint.
Yes,
Then
madam.
what, because we are not going to
Yes,
decide who is
madam.
right, who is wrong.
Yes, ma'am.
We are going to decide whether Women's Commission who can continue with the proceeding or not.
Or not.
That's all.
That's all.
Yes, now we know who is who.
So now on the basis of that,
This complaint.
now what happened is that they have filed a complaint before the Deputy Director ICDS Protection Officer. It's on page 36. There's one more complaint is there. page 36.
Now what happened to those?
This one, my lord,
These will not.
not much, my yes.
Will not deal with.
Yes, my lord.
Because these are not our subject
Yes.
matter.
So another complaint is under Domestic Violence Act.
Where is that?
It's in page 40.
40.
It was filed on, your lordship may see the date is in page.
Just give me the day of complaint filed by Shrine
Yes.
against Jimmy or
Jimmy.
any other person.
Yes,
Give
ma'am.
us those applications.
Yes, madam.
Yes. Which are
So
those?
another is in page 40,
Page 40
40.
is, one is before the Women's Commission,
Women Commission.
one is before that in the domestic violence, okay?
Yes, domestic violence. Yes. ma'am.
Then
One is before the Chief Judicial Magistrate.
where is that?
It's in the page 40. It starts from page 40.
40?
40.
40 says domestic violence.
Yes, my lord.
Then-
And date is, my lord, date is 27 April 2023.
Anyway, did forget about
Okay,
it.
okay, my lord.
This merit of these petitions we cannot deal with.
Yes, my lord.
In this proceeding.
Yes,
Then any other complaint?
Then what happened? The complaint which was filed by the respondent number 4 to the Women Commission, that was referred to the National Women Commission.
So you want to say the complaint laws before the Women's Commission on 28/4/2024 was referred to the,
National Women Commission.
where is that?
That is in page, my lord, may I see page 65.
Page
65.
Your Lordship, I would like to add here. Actually, on the same date, two complaints were filed in the Women Commission. One was against her husband, Jimmy Chiram. Since Jimmy Chiram is a central government employee, so that complaint was forwarded to the NCW.
Understand.
Rest.
Because they do not have the jurisdiction, it will have to go to the National Commission. Where is that?
Page 65, my lord.
Page 65.
65, the matter was, this was forwarded before the,
It is against the Jimmy,
yes, my lord.
not against this other person.
But this is related to marital affair only. So marital affair means Jimmy and the respondent, sorry,
No, that is
petition
a
number 1.
different issue.
Yes,
Question
madam.
is, that is not the question. Question
madam.
is, see, according to her, her marital right is destroyed by
Yes, that is,
her husband, that is Jimmy. And they had a love marriage, they went in Bangalore and all, and
Yes.
according to her, Jimmy is a salesman now because of this respondent number, this petitioner number 1.
1.
Is that it? Okay. And so far relating to others, according to her, these are the relatives of respondent number 4 who also instigated, who was also instrumental in her leading to this situation and her reason for her marital discord of a happy family.
Yes.
This is the sum and substance. Okay, so therefore, there were two complaints. One is against Jimmy and other is against the other part, who are the, say, Jimmy is the commandant and other are the all the forces.
my lord, other is that when,
Exactly.
when there is a complaint before a GMFC,
Hmm.
Judicial Magistrate First Class, when there is a complaint before the district court, can there be a parallel jurisdiction of the
Now
Women
let us see
Commission? That's-
the power.
No power, I will just see, yes,
See here in this case, nobody is going to decide whether Jimmy is right or Shrine is right.
yes, my lord.
This is a subject matter or somewhere else. Here, our decision is that Jimmy is having a complaint, whether that complaint can be determined by a Women's Commission. First question. Second is, even if its Women's Commission is having jurisdiction, whether when the moment Jimmy approached the competent civil court or a criminal court, whether Women Commission's jurisdiction will cease.
Yeah, that has,
That's all.
your
So
lordship
let
have to
us
see
not
that.
go who is
Yes,
who.
my lord. Your lordship have to see that one, my lord.
Yes, so as the law now.
So now, I will just, the complaint which was filed before the State Women Commission, as per the Act, my lord, it is It is in the counter affidavit filed by the respondent number 2 and 3.
Just a minute.
Commission.
Yes,
I want to refer the counter affidavit filed by 2 and 3. 2 and 3.
Yes.
Yes. And then I want to take to the provisions which they have annexed the Women Commission Act.
Okay, they have
Annex, yes, my lord. And then the relevant paragraph, I also want to read that one. My lord, relevant
page
paragraph is
86. It starts at page 86. Act 1990.
my lord,
Which page you want to show me?
affidavit of opposition filed by 2 and 3.
Page.
My lord, page 5.
So continuous page, running page.
Page 5, my lord.
If you repeat it here. I think affidavit is here. No, affidavit file I will see.
एक तो हम लोग रेफर नहीं किया ना एक नहीं है ना एक
If you take it off, there is no indexation also. It's a difficulty. Your read petition contains how many pages? Okay. Let me explain. Okay. Affidavit by
affidavit filed
2 and 3.
2 and 3, my lord.
Okay. Page 5.
Page 5, para 9, second paragraph. Arunachal Pradesh Women Commission Act 2002, Section 3 states that
Respondent number 2 and 3.
it was filed on which
Just a minute. Just a minute. Paragraph.
paragraph 5, my lord.
Paragraph. Yes.
Page 5.
Okay.
Page 5, may I read the second paragraph? The APSCW Act 2002, Section 3 states that APSCW Act shall not be applicable to the central government employees. Hence, the matter concerning the respondent number 4, husband who is an IPS officer, was forwarded to the National Commission for Women and NCW New Delhi. So now this is as
So
for
according to your, there is a suo motu proceeding without complaint.
yes.
This is your case?
No, my lord, complaint was filed
And
same was forwarded to the national NCW. My lord, act, my lord, just
there is nothing.
yes, my lord.
Both
Act, my
the
lord,
parties to ensure their presence in the scheduled date on 12/5 for preliminary. However, say it was postponed then.
my lord, act is page 17, my lord.
Page
17, 17
of the affidavit.
of the affidavit.
Yes.
The act not applied in certain cases. The act shall not apply to central government employees, to any public sector undertaking central government or any other institution owned or controlled or financed directly by the central government, provided that if any case involving person or person belonging to these categories comes before the state commission, the state commission will have the power to refer the matter to the National Commission of
Okay,
Women
fine.
with its finding and recommendation. So now the matter was referred. And then the NCW have heard the matter, the same complaint, heard a matter, and said that when you have a matter in the civil court, when you have matter before the, it was admitted that even divorce petition was also filed for the civil court. Now the NCW says that then the matter closed there. That's what in our writ petition we
That
have.
I've seen that. That's
Yes.
signed by those.
Yes,
three, four.
we are closing the matters. Now, how now after closing that matter, they have filed complaint under a Domestic Violence Act, under for even the husband of the respondent also filed for divorce petition. And this all parallel is happening under that after that only the Women Commission issues the fresh notice to the petition number 1 and are the families of the petitioner, saying that you should come and answer the matter.
According to petitioner numbers, decision was taken by the National Commission.
Yes.
Re-
So
Menor-
allegation is extramarital affairs. Allegation
Okay,
is extramarital
we'll
affairs.
come back after 5 minutes. Basically, that they are not having jurisdiction. And secondly, that already similar issues between the same parties have already been decided. Therefore, this is not.
Filed before the law court. And some other cases are pending.
And other cases are also pending
Yes.
where relief can be granted.
Yes, Father.
Any judgments you want to rely? No.
Judgments,
Okay, not necessary, not
Not necessary.
judgments. Yes, madam.
Your Lordship, actually, I would like to rely on this judgment. And this case is not only regarding alleged marital affair. She was also pregnant then, and now she has also delivered a baby. And they are still together, residing in Delhi.
Now, what is this case?
This case is, this is also a domestic dispute case where para 10, I would like to,
Para.
para 10. Because all the powers and functions of all the women commission all over state is almost more or less the same. We have the same powers. So in this, basing on para 10, may I just go through it? The commission has the power, the court has
No, no,
decided.
power is no doubt.
And here
But
it is,
two things. One is having power and to exercise it.
and here, your Lordship, we had only called for the preliminary inquiry. Till date, no inquiry has been done because the petitioners, they never appeared. So without any inquiry, we have not made any inquiry.
Okay, fine. Let us see what is your prayer in the court. Allegations are fine. What do you want? What actions to be taken by the commission against these people? What is your prayer?
Okay, we want that this petitioners, for as of now, petition number 2 and 3, who are the parents. So they may be excused for now.
Okay, okay.
But later on, they can
Okay.
be directed.
What about against one, that is your husband's friend,
Yes,
isn't it?
yes.
Now, what is the relief claim against her?
Your Lordship, actually, we want her to be present in the commission. See, commission.
No, present is fine.
Yes.
You need some relief.
Hmm.
That I want this relief or it should be done this. So therefore, his presence is necessary. We first want to understand what do you want to have an inquiry.
Actually, when this case was, when the complaint, we had received this complaint, the lady, respondent number 4, the complainant, actually she wanted to sit and talk with the lady, the petitioner, so that the matter could be resolved because she has never approached her. She has never met her in person. So she just wanted that commission should just, she might be called and they could
There
just
should
talk
be
it over to,
settlement.
yes, settle the matter so that
Let us
she
see
stay away
once-
from
let us
her
see
husband.
Once again, your complaint petition, on the basis of which direction was issued. Where is that? Space.
Your Lordship, I'm for the commission.
You are for the commission.
For commission.
Who is for the lady? Yes.
Your Lordship.
Yes. Okay, commission we understand. Okay. Yeah. What is your read? Where is
Your
your
Lordship, this petition is not maintainable as they tried to lie before the National Women Commission as well as they tried to misguide this honorable court.
Okay,
It
fine.
is evident in page number 66A itself, Your Honor.
66A.
Yes, Your Honor.
That can be good talk for this.
Yes, Your Honor, wherein they have mentioned that the case has already been decided by the lower court. In actual, Your Lordship, it has not been.
Which space?
Page 66A.
66?
A. May I read Your Lordship?
64, 65,
66A.
66A.
During the hearing dated so and so, it came to the notice of the commission that the matter regarding the marital cruelty has already been decided by the court. The husband has informed that he has also filed a divorce petition in the court. The commission did not receive any information on any court case with the original complaint registered as case number so and so. Since the matter has been decided by the court, the case is closed. Your Honor, the matter is not, it's still pending in lower courts.
Who informed you this?
Your Honor, my signature, respondent number 4 signature is also there. Your Honor, they have forcefully, without letting me go through the orders, they have let me sign, and to save my marriage life.
By the client of your friend, meaning their wife.
No, Your Honor, by the NCW.
National Commission for.
Just to save my marriage life and the future of my 2 daughters, minor daughters, I have signed without going through the order. And Your Honor,
No, all these are fine. These are not the issues here. Let us see your complaint. Where is the complaint? We want 40, page 40,
Page 20, my lord.
page 40.
20. 20. Complaint before the.
Against this present petitioner.
Yes, page 20. Not only against the petitioner, even against the respondent of forced husband, my lord.
Uh-huh.
Both.
Yes.
Your Lordship, they have made allegation on us that we have filed a series of complaints just to harass them. Actually, it's not. It is totally baseless and false. Before proceeding with lower courts, we approach Women Commission for positive response to safeguard my marriage life. But after not getting any response, it is evident in order dated passed by this honorable court on 9/6/2023, that is stay order passed by this honorable court, that we have, after that only, Your Honor, we have filed in lower court, civil court.
Now, everything you have opted for domestic violence proceeding and all. What the Women's Commission will do now?
Actually, sir, before going to the
So
that court,
that's fine, but in the same situation, you have already opted the actual remedy which you ought to have before going to the Women's Commission. Now, what remains sending you all to the Women's Commission?
yes, Your Lordship.
Nothing. That's why it was closed. We will also close it.
Sir, my submission will be to dismiss this matter to safeguard my marriage life and the future of my daughters, two minor daughters. Actually, it is me who is facing real problem.
Women's Commission cannot save your marriage life. Already domestic violence is pending. Already husband has filed divorce that is pending. Now it's difficult.
Sir, if this matter gets,
Dictate this order.
sir, if this matter get dismissed, it will be little help for me.
Just help me in dictating the facts. Hard. The present petition is filed under Article 226 of the Constitution of India by 3 petitioners, namely Karpu Sisi, Sri Hankar Sisi, and Srimati Yapi Sisi. They are aggrieved by an notice dated 30/05/2023 issued by the Arunachal Pradesh State Commission for Women, for short APSCW bracket close, on a complaint filed by respondent number 4. Full stop. a complaint was lodged, the facts which are not disputed by either of the parties are to the following. Full stop. The respondent number 4 lodged a complaint before the APSCW on 20/04/2023. The fundamental allegation is against the husband of the complainant, namely, what is his name?
Jimmy Chiram, it's in last.
Jimmy
Chiram.
JIMMY
YCHIRAM.
CHIRAM, which involves marital discord. Full stop. One of the allegation of the complainant is that her husband is maintaining an extramarital affair with petitioner number 1, for which her family life has been ruined and her husband started misbehaving and started cruelty upon her. The other two petitioners are relatives, that is mother and father of the said respondents, the petitioner number 1. Full stop. Full stop. The record reveals that during the pendency of this present petition, the respondent number 4, within bracket wife, had also filed an application under Section 12 of the Protection of Women from Domestic Violence Act 2005, and seeking amongst other protection orders, full stop, which has been registered as domestic violence case number 15 of 2023. The said Jimmy Sriram, JIMMY, Jimmy Sriram, within bracket, husband, had also in the meantime filed the divorce petition being, yes, what is the divorce petition number?
My lord, the petition. Let's just check. Yes, sorry, TDS, TSD,
TS within bracket D
27/2023,
27/2023,
Jimmy Chiram versus Srimati
2023,
Nima,
which is now presently pending
Pending.
for adjudication before the learned
District Judge UPA.
District Judge UPA. District Judge UPA. In the aforesaid backdrop, before proceeding further, the learned counsel representing respondent wife submits that she has no grievance against the petitioner number 2 and 3, and therefore she will have no objection if the proceeding against them before the Women's Commission is directed to be closed by this court. Is it correct? Not correct. Okay, not necessary. Okay, not necessary. Fine, Christopher. The learned counsel with the petitioner has fundamentally urged that a bare reading of the complaint lodged by the respondent wife dated 20/04/2023 shall not disclose any case any case to confer any jurisdiction upon the commission to exercise its jurisdiction or to issue notice, more particularly to the respondent number 2 and 3. Therefore, on this count alone, the name of the respondent number 2 and 3 should be deleted from the proceeding of complaint case number so and so, so and so. What is the number?
Number two, sorry.
Number of the complaint that was registered?
Well, respondent number 2 and 3.
2 and 3. What is the number of the complaint?
Complaint.
Its notice was issued in which complaint?
Complaint is, my lord, dated 28/4/2000.
28/4. From the complaint of the 20. There is no number.
There is no such number.
Okay. 28/4/2024. 2024. In as much as 2024. So far relating to the petitioner number 1, it is the contention of the learned counsel for the petitioner that though there are certain allegations of domestic violence, etc., and cruelty that has been meted out, alleged cruelty that has been meted out upon the wife by the petitioner number by the husband. However, the allegation being an extramarital affair of the husband of the respondent number 4 with the petitioner number 1, such dispute cannot be determined by APS, by the commission. Full stop. Alternatively, the learned counsel for the petitioner also argues that as the parties has approached competent court in between, which can the erring parties, not erring parties, the husband and since the husband and wife both has approached appropriate forum for redressal of their grievances, the present petitioner number 1, who is the third party to their dispute, should not be allowed to face an unnecessary litigation inasmuch as the respondent number 2 and 3 are nowhere connected. Per contra, the learned counsel representing the Women's Commission submits that the notices were issued only with an object that the matter can be amicably settled between the parties so that parties remains present before the commission. And according to her, commission shall not be powerless to go for such a procedure so as to redress the grievance of a woman. Full stop. This is your case. And accordingly, the learned counsel representing the Women's Commission submits that the Women's Commission shall have jurisdiction and competence to proceed in the matter. The learned counsel representing the respondent wife submits that this present petition is liable to be dismissed in limine for the reason that the petitioners are having an efficacious alternative remedy before the commission itself, inasmuch as only a notice has been issued and the commission would have decided whether they are having a jurisdiction or not. Therefore, and they ought not to have rushed to this court for seeking judicial review of an order of issuance of notice, and therefore on this count alone, the present petition is liable to be dismissed. She further contends that since there are specific allegations against the petitioner number one as regards the marital discord in her life, therefore, prima facie case being made out, the commission has issued the notice, and in that background, this court should not exercise its power of judicial review to determine such dispute, for which a commission has already been constituted by the state legislature by enacting so and so act. Full stop. She further contends that though the proceeding was closed, and she also signed such closure of proceeding against husband, isn't it? Against the husband.
Husband and wife.
Husband and wife. However, she signed those, she put her signature without knowing the effect of such action, in as much as a wrong fact was recorded that the dispute has already been resolved. Therefore, such signature cannot be a ground for allowing the present petition. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. Okay. Women's Act 80, some. What is the law? Act. Any special act, Arunachal Act? Where is that? Anything annexed? Or is some like Assam?
Counter affidavit filed by respondent number
Give
two
the
and
page,
three.
give the page. Or give a book, either way. Which page? Reference Commission is there. Which page?
Affidavit filed by respondent number
Page.
two and three. Page is my lord.
Respondent number 2 and 3.
Page is 16.
Huh?
16 page.
The complete,
No, not complain. I want the act.
complete act book is, page number 117 onwards.
117 of writ petition.
Petition copy.
Okay. I have seen some, sir. 117.
Yeah.
Okay.
But however, I submitted that act book on the previous occasion.
Okay, my lord, on our petition 117.
Huh?
Our petition 117.
Okay. The state legislature in Arunachal Pradesh has enacted Arunachal Pradesh State Commission for Women Act 2002. Section 15, section 14 of the Act empowers the commission to commission no, not for section 15. Section 15 of the Act enumerates the function of the commission, which includes the relevant for the case is What are the provisions?
Clause 5, one clause A,
A,
clause 1, subclause A, inquiry into any unfair trade practices.
what is unfair trade practice?
Yes, that is not defined in unfair trade practices, my lord, in this act.
Unfair practice would be defined under.
Oh, okay, it's in definition in number 2. Section number 2, 8.
2(8).
Yes, my lord. Subclause 2, subclause 8. Means any distinction, exclusion or restriction or exploitation made on the basis of sex for the purpose of or which has the effect of impairing or nullifying the recognition, enjoyment or exercise by women of a fundamental constitutional rights or a human rights or a fundamental freedom in the political, economic, social, cultural, civil or any other field for or infringement of any rights or benefits conferred or women by
Okay. Amongst other, more particularly, amongst other, to inquire into unfair trade practice, take decision thereon, and to recommend to the government the actions to be taken in the manner, which is most relevant function for the determination of this case, in as much as the other provision relates to submissions of annual report, make recommendation to government, the welfare measures to be adopted and implemented by the government with a view to uplift the condition of the women, formulate upliftment of the women, then formulate comprehensive schemes for women. Even it can recommend the government to initiate legislation for removal of discriminations in case of inheritance, guardianship, etc. One of the power and function given is to hold family court to dispose of cases related to unfair practice against women. Unfair practice is defined under section 2 within bracket
2 subclause 8.
2 subclause 8 within bracket 8, which means any distinction, exclusion or restriction or exploitation made on the basis of sex for the purpose for or which has the effect of or impairing or nullifying the recognition, enjoyment or exercise by women of fundamental constitutional right or of human rights or fundamental freedom in political, economic, social, cultural, civil, or any other field, or infringement of any right or benefit conferred or under provisions of any law for the time being in force, etc. etc. Therefore, a reading as a whole, the function in the context of the present case or a family dispute like the present one deals with holding a family court to dispose of those cases. However, from under the scheme of the provision, the power of the commission is recommendatory only. Full stop. Power of the case is recommendatory only. Subsection 16 deals with the procedure of inquiry into unfair practices. In terms of the aforesaid section, after receiving a written complaint by any woman alleging that she has been subjected to any unfair practice or on its own knowledge, it can issue any process to person complained against, cause a preliminary investigation to be made by the member secretary, and appears to show cause or fails to, or announces notice if the person appears the commission may proceed into the matter and take a decision thereon. And thereafter, it may make a recommendation within 2 months from the date of receipt of the recommendation, recommendation to the government, and the government is to act on the basis of such recommendation within 2 months. 2 months from date of such recommendation, and a decision thereon is to be taken. Full stop. Therefore, under the scheme of the Act, though the Commission is having a power to issue notice and make a recommendation, however, these recommendations are having no binding effect upon the government to implement. And it is that such recommendation is left to the wisdom of the government to accept or not to accept. In the aforesaid legal and factual context, there is no hesitation in the mind of this court that in a given case, a commission will have a power to issue notice to a person in strict adherence of the procedure laid down and function enumerated under the scheme of the Act. Under the scheme of the Act. At the same time, the scheme of the Act. In this context, it is important to note the determination of the Honorable Apex Court in the case of Bhavani Prasad Jena. Bhavani Prasad Jena reported in so-and-so. Reported in 2010, 8 SCC 633, wherein the power of the commission was dealt. In that context, in the aforesaid case, the Honorable Apex Court, in no unambiguous term, held that in that case, dealing with the Act of State of Orissa, which is perimeteria to the which is a perimeteria provision of the APSC Act, held that the Commission has been authorized to take up studies in respect of economic, educational, and health situation of women in the state, also the working condition of women, etc., which is also discernible as discussed herein above in the case of APSC, which includes in even the recommendatory nature of the recommendatory power of the Commission when there is recommendatory power of the Commission to recommend legislation when after inquiry, it comes to a finding that as regards the condition of women, so far it relates to personal law, including inheritance. In the aforesaid judgment, after discussing the scheme of the act, the Honorable Apex Court concluded that though the State Commission may receive complaint in relation to appropriate remedial measure, it has not entrusted the State Commission with the power to take up the role of a court or any adjudicatory tribunal and determine the right of the parties. The State Commission is not a tribunal discharging the function of a judicial character or a court. Therefore, the prescription made under sub-rule P under section 8(1) within bracket, no, not section 18, section 15 within bracket 1 within bracket P, empowering it to hold family court to dispose of cases related to unfair practice cannot be read to have in derogation of Family Court Act or the or a court empowered to adjudicate any matrimonial dispute, including divorce or domestic violence or any offenses under Domestic Violence Act. More particularly, for the reason that under the scheme, more particularly under section 15 of the Act, the Commission's power is in the nature of recommendatory. It cannot conclude or decide any adjudication. Therefore, in the aforesaid context and in the given facts of the case, which is admittedly an allegation against the petitioner number 1, that the petitioner number 1 is having an extramarital affair with the husband of the complainant, and complainant cannot be adjudicated by the tribunal, more particularly in the changed circumstances that such dispute as regards divorce as well as the cruelty meted is pending adjudication before competent court, competent court. Full stop. Yet another aspect of the matter is that if we read the complaint as a whole and take everything to be correct, such fact in the considered opinion of this court will not come within the meaning of unfair practice as defined under section 2(8) of this act. That is another reason for which, if the parties are relegated to the commission, that will be an abuse of the process of the process, in as much as one party will be forced to face a proceeding which is not necessary and which can be adjudicated by the competent courts. In view of the aforesaid, the present writ petition stands allowed by setting aside and passing so and so. Will not get the order today itself. It will need fine tuning.
Obliged. Obliged.
Understand now? This is the issue. We keep this file in a chamber. After dictation, we put together. Okay, upper the learned counsel for the respondent by relies on the decision of Honorable Apex Court of the Manipur High Court in 2016, SCC Online Manipur High Court. So far relating to the judgment relied on by the petitioner, respondent number, counsel for the respondent number 4, this court is having no quarrel with that proposition in as much as in a given case, the commission will have a power to issue notice. However, this is not the case where it ought to have issued the notice. This is different. Item? Agree enterprises. How many matters are left now? What is the next item? This is item 15. Let's go serially. Well, what was the last item? Huh? Item number 6. No, let us go serially.
Your Lordship, the conducting senior counsel, Mr. A. Apang, has instructed me to mention before Your Lordship that the pleadings have been completed and the matter may be listed for hearing after 3 weeks, Your Lordship.
Okay, hear it today itself. Okay, who is for the respondent?
Lordship, I am for state
You're a
respondent.
state, you don't have any problem.
No.
It's a private dispute.
Private dispute.
Private dispute, you have your DCI exercise, they say you don't have an exercise. You'll have to decide whether it's a civil dispute or whether it can be exercised.
Your Lordship, we have
Who is the-
taken the consent of the other side.
Consent for adjournment or consent for admission?
Your Lordship, we have mentioned it to them that we'll
So
go
on
it
the
for
behalf of
hearing
the learned counsel for the petitioner, list this matter
after 3 weeks. Highly obliged, Your Lordship.
Yes, Mr. Singh.
My lord. My lord, this is my lord, writ petition, my lord.
Hmm.
Filed by the my lord petitioners who are the victims, my lord. They profess, my lord, the Buddhist religion, my lord. So their monastery.
No affidavit has been filed. Why not?
We have filed our.
Huh? You have filed. Pleadings are complete.
5 and 6.
Now final report granted or what?
My lord, final report, they are saying that although offense has happened, but we are unable to find out that. But circumstantial evidence, my lord, of course, there cannot be direct evidence.
No. Two aspects here. One is they have done the investigation.
My lord.
Now what is the investigation complete?
My lord, final report submitted. I submitted protest petition. First time, my lord, protest petition was allowed. Further investigation directed. Subsequently, also, my lord, just for namesake only further investigation was carried out. Again, final report was submitted. I also submitted protest petition, but this time the final report was accepted.
So that order is under challenge.
That is also there. Basically, my lord, I am here, my lord, seeking, my lord, that this, because the police is saying that we are not in position to find out the victim, my lord. Now we are saying, my lord, at least for ourselves, we are not satisfied the manner in which the investigation was carried out. We are praying this honorable court.
You're not satisfied. There is re-investigation.
My lord, that's why, my lord, the same agency earlier did, my lord. That's why we are here, my lord. At least, my lord, this time, my lord, case may be transferred to the, my lord, special crime branch, my lord. So that
at this stage, was our, why should we exercise that power when twice it was returned?
My lord.
And you filed an RG petition,
My lord.
protest petition you have filed.
My lord.
That was upheld. First, we will have to come to a conclusion that this is absolutely not tenable. This is one aspect. And this is not a writ petition for, cannot be a writ petition because you have awaited till, you have not lost any grievance initially that this, we do not want this investigating authority. You had a chance, the investigation is granted. At this stage, once again giving it to the fresh authority, we'll have to have a super satisfaction.
Hello. I understand.
Super satisfaction that yes, absolute on the open the file and see it such an illegal.
Here,
then only we can set aside the order of the magistrate. Then we can Of course, recourse power is not limited. We can do that, but that satisfaction we require. For that, we want to see the case diary.
We have filed our affidavit. Case diary, my lord, we have not called for that.
That is most vital. Affidavit will not decide all these cases. We'll have to see the case diary.
Case diary, then maybe call for it.
That will be required. Even a scan copies will we can call the record from the magistrate.
Yes.
That will do.
My lord, in the records, case diary may not be.
Or Arunachal you do not, but in Assam it gives the case diary everything. Okay. The present petition has Mr. R. Sunar, learned counsel for the petitioner, and Mr. N. Rotan, learned additional advocate general for state respondents. The present petition under Article 226 of the Constitution of India is filed seeking a direction to the respondents to carry out a fresh and de novo investigation of Ying Kion, YINGKION, police station case number 30 of 2021, by the crime branch police station within bracket SIT PHQ Itanagar. Full stop. To have to issue such an order, amongst other, this court will have to have a primary satisfaction that investigation was not properly done. Earlier investigation was not properly done. Therefore, therefore, this court shall require to go through the case diary, and in absence of which a final determination cannot be made today. Full stop. Accordingly, Mr. Ratan's learned additional AG through his office shall produce the case diary of so case on the next day fixed. List this matter. After 2 weeks?
After 2 weeks.
2 weeks?
2 weeks.
After 2 weeks.
Much.
Yes, Tara. Gradation list.
Well, please, Your Lordship.
We'll continue at 2.
Lordship.
Yes. Okay, we'll decide. Or should we first should we first finish up this order matters? Then we can come back.
That's also okay, Lordship.
Okay, we can start also. Generally in my court in Guwahati, first is motion, then orders, then only admission. So that orders matters are steps, these, that, this can go and we can concentrate on hearing. And we'll see from tomorrow. Yes, we can notify that. So at 2?
Yeah.
At 2 will come back. Yes.
May I please, Your Lordship.
Which petition will take up?
My lord, can we take up serial number 17 first?
Serial
WPC
number-
218,
Last one.
the second last one.
Okay.
WPC 218 and 217 were filed
Okay.
earlier. Then thereafter, item number 15 and 18 were filed.
So 218 will take up for first.
Yes, it's all, the facts are almost the same except for few differences. The issue Your Lordship must have seen cursor on a first glance is there are only 2 issues here.
whether in the matter of promotion, vis-a-vis the direct recruits and promotees, whether if it is done after the pronouncement of the judgment of K. Megachandra, whether farmer case will still apply. That is the issue.
Okay.
Because in this case, what happened is, in the matter of interstate seniority, farmer case was applied even though the fixation of seniority was done later than Megachandra's case.
Yes.
Then another issue, very vital issue I might add, is the respondents are not direct recruitees
Okay.
per se. They are actually limited departmental candidates. For promotion, they held this kind of
Okay.
they held this kind of exams. So this is a promotion. This is a accelerated promotion, but promotion nevertheless.
Okay.
So if this issue is decided in my favor, then we did not even go to Megachandra and all this. These are the two issues, Lordship.
Okay.
Now the
So let
facts.
us understand the fact.
Yes.
Facts first.
They were in case of
All are represented, all parties are represented.
yes.
Notices are duly served upon all.
Yes, they file affidavits and all. In the case of item number 17, which is the first case we're taking up,
218.
218, the petitioner was promoted to the post of assistant on 02/03/2000.
This relates to which department?
This is Civil Secretariat.
Okay, civil secretary.
Yes, but we are concerned with the post of seniority in the section officer. Section officer is a promotional post from assistant.
Post where it is contested by both the side is
Yes.
senior assistant.
No, section
Section-
officer, which is a promotion from assistant. So,
Promotion from assistant. Okay.
yes,
Feeder cadre is assistant.
assistant. The promotion order is at page 30,
Yes.
his promotion order.
So this will be kind of similar promotion orders.
Yes, the dates are different.
Okay.
Dates are a bit different. In case of the another writ petition, it's a bit different. It's in 2016.
Page 30. Okay.
Yes, page 30. He was promoted by the recommendation of the DPC. From the date of the DPC, that is 24 January 2014.
Okay.
But Your Lordship, I will admit, in the seniority list, the date given for his promotion is of 2013, the date on which officiating promotion was given. But that is not an issue here.
Okay. If not, this will not. go.
Yes.
Just a minute. I'll just sign two. Yes.
Lordship has seen page 30.
Ah.
My name appears at serial number 5.
Okay.
That is Larjum Doi, the petitioner here. Thereafter, Lordship, after this Lordship, he was given pay scale and everything. This is not an issue again. Then a final seniority list was published of assistants at page 32, Lordship. This is 11 December 2015. Here, my name
Just a
appears.
minute.
Yes.
Okay. Where is that?
There is the page 32, starts at page 32.
Page 32.
This is the final seniority list of section officers. At page 34 is my name. This is serial number 63.
Okay.
So this is the final seniority list of the section officers. At that time, your lordship may note the respondents, the private respondents were not, I have not been mentioned in the list because they were not promoted
Okay. So
on
according,
this date.
okay, on this date, this was a gradation,
Final seniority.
final seniority list.
Yes.
In the feeder cadre.
No, in
Or
section
the-
officer.
In the section officer.
Same section officer. What I mean to say is
Hmm.
my seniority position was already crystallized at that point.
Yes.
This is 11 December 2015.
This is.
11 December 2015. So seniority, this was the final seniority list. At that time, because the private respondents were not even section officers, they were still assistants. So therefore, their name is not here. Then lordship, for lordship may revert back to the recruitment rules prevailing at that time, page 27.
Just a minute. That pencil, green pencil, green pencil. Yes.
The recruitment rules
Recruitment is at page.
at page 27. Second
Just
June,
a minute.
sorry,
Page
27.
27.
This is the recruitment rule for the post of section officer, 2004.
Okay.
Here, for the method of recruitment is 50% by promotion, as in column 12, then 50% by limited departmental competitive exam from amongst the assistants of IP Secretariat who have rendered 6 years of regular service.
Now, where is the dispute here?
There is no dispute here.
No, this dispute is regarding determination of seniority.
Yes.
Determination of
Yes.
seniority. So according to you, your seniority just, it's a preliminary.
Yes.
Your seniority is bypassed after their promotion.
I was already working as section officer. Already my position was crystallized by the final seniority list. They have
By whatsoever mean,
yes,
forget
yes,
about.
yes.
By whatsoever mean, they entered into the cadre of section assistant subsequent to you.
Subsequently, they entered, and then
therefore,
after
your
the
seniority should be maintained.
yes, after their entry into the section officer, they were interpolated in the seniority list. In between the
On what basis?
saying that the year of initiation of recruitment, saying that in 2013, although they were appointed in 2017 and 2019 respectively, the year of initiation was in 2013, which is
For promotion to the
section officer by departmental exam.
Okay.
The year of initiation, that is
So therefore, their promotion should be treated in the cadre of section assistant from the date of their examination.
yes, not examination,
Not from the date.
from the date of initiation of recruitment.
Initiation and not from the date when their actual promotion.
Yes,
was issued.
yes, yes,
This is the
yes,
case.
this is the
Now,
case.
what is what the rule prescribes?
The rule does not prescribe anything to that extent. Rule is silent on that.
Okay.
So we'll have to follow the precedents here.
Okay.
The memorandums, Lordship.
Now, what about this earlier judgment that farmer's judgment or what?
Farmer judgment, Lordship, that it is very interesting. Farmer judgment said, well, interpreting the OMs of 7/2/1986 and I forgot the other date. Wait, there were two memorandums which were interpreted by Farmer's judgment. saying that the year of recruitment would be the year at the initiation of recruitment, not the year on which the exact exact appointment is done. That is what Parmar said. Now, this case was,
Overall subsequently, or some interpretations were made, Parmar's case.
yes, interpretations were made, but in Megachandra's case,
Hmm.
which was in 2019,
Hmm.
the court said that the Parmar's judgment was incorrect. In fact, the interpretation of those memorandums were also incorrect. Interpreting those memorandums, some OM was published in the year 2014 also. So, but the Supreme Court said the whole interpretation, even though the OM that in 2014, which relied on the OM 1986, that also was incorrect because the 1986 OM did not say that. That is what.
Now what are the promotion orders of these respondents? Where are the promotion orders?
Promotion orders was,
in favor of these respondents to the sectional assistant.
yes.
Where, anything annexed?
No, that I have not annexed, but it is in the seniority list.
Now the next seniority,
Yes.
which is under challenge.
Yes.
Let us see.
Your Lordship will find in in respect of respondents 3 to,
Just give us a sample.
3 to 8, 3 to 6, their promotion orders are said to be on 8/8/2017. In respect of
8/8/2017 means the date when it was initiated.
no, they are taking it to be 2013, but here it is given 2017.
Now, if
But the
it is
interesting part is, Lordship, those people who were appointed in the year 2013, they were placed above those people who were appointed in 2013.
So you want to say, though the gradation list, it disclosed actual date of promotion.
Yes.
However, they were placed higher than the persons who already entered into the cadre.
Yes.
This is your case.
Yes.
Now let us see the judgments.
Yes.
And what will be a Tititara's case?
In this because it is a two different source of equipment. Therefore, the 50/50 roster has to come in. And then I am under protection by 2021 notification.
No, we understand. This is the preliminary thinking.
Yes.
This is preliminary thinking. So you want to say direct recruit and promotee. You want to say that. Now direct recruit and promotee to which cadre?
Section officers.
2 section officers. So 2 section officers. According to you, you are the direct recruitee and they are the promotee. Now, if you are a direct promotee on the basis of their seniority, and you are on the basis of the limited departmental examination, otherwise you are not qualified. So therefore, to maintain 2 different rosters, to different portion, then there cannot be any common seniority list. What is the next promotion? What is the next promotion?
Under secretary.
Under secretary. Any quota for under secretary, or it is a seniority only?
Seniority, there is seniority only.
Huh?
Seniority only.
So seniority only, then you'll have to make a common cadre. If it is a common cadre, then date of promotion. No, carry forward up to the sectional officer. So moment you reach sectional officer at a later point of time, maybe through direct recruitment, maybe examination initiated, you reach the compartment at a later date. You enter into the railway compartment at a later date. If you say that no, to the next compartment, there are avenues for you and you both to go, and therefore there should be a separate gradation list. Well and good. But if you say thereafter the compartment is same, road is same, there is no 2 ways.
That is, I'll have a per contra view. The per
No,
contra
no,
view-
of course.
The per contra view is,
Hmm.
there is an OM,
Hmm.
which is a standard.
Hmm.
These particular OM has not been fully challenging this rate.
OM issued under what provision of, under
In terms of the mega chapter.
Mega Sunrise, earlier Mega Sunrise judgment,
No, the later one,
later one.
later one.
Now, if Mega Sunrise judgment no more remains, what is the validity of the second?
So, sorry, Lordship, Parmar judgment.
Permanent judgment.
Yes, Parmar is no longer there.
So
Yes.
notification has issued.
Firstly, they carry forward.
So your whole case is that my right accrues on the basis of the 21 office memorandum and that not being put under challenge, even if that there is a wrong, that cannot be touched in exercise of power of judicial review. This is your argument. Otherwise, I do not think any other argument can be that we are, it should be from the dead date and all.
That no place it then I have.
We have understood the case.
Lordship, another very vital aspect of the case is that there is a division of 50% post for limited departmental promotion candidates and for regular promotees. For being eligible for appearing in those limited departmental exams, one has to have 6 years of regular service in the feeder cadre, that is assistant, the same feeder cadre from which promotions are made. Now, my learned friend has said, of course, that there are two sources of appointment. There may be two sources of appointment.
No, it's not two sources of appointment.
That's what I'm saying.
It's not two sources of.
This is just a division of.
No, it's a promotion giving one who is already one is only on basis of seniority.
Yes.
Who already achieved the benchmark seniority.
Yes.
Say suppose 10 years of service on the basis of seniority.
Yes.
And others, 50% will give for merit.
Yes.
That you compete in merit.
Yes.
And you'll reach that door. Your
Yes.
route is different.
Yes.
You don't have you have not achieved the seniority. That minimum period. Therefore, you'll have to pass the examination.
Yes.
Isn't it?
Yes.
So there should be a benchmark seniority for other persons also to get in seniority. Let us see the rule first, therefore.
No, Lordship, I'm sorry. The benchmark is the same. 6 years.
Okay.
6 years. For both, it is 6 years. But there may be cases in which that post, there is less number of posts, for example.
Benchmark is 6 years.
Yes.
Okay.
For both.
For being eligible to be promoted to the next cadre.
Yes. And also
being eligible to be promoted.
Yes. And also to appear in the limited departmental exam.
Being eligible for promotion.
Yes.
There are two ways of promotion.
Yes.
One is on the basis of merit.
Yes.
Those are kept, 50% vacancies are kept for those who will get in on the merit on the basis of the gradation list.
Yes.
This is one. And those who have got 6 years but is below the criteria or whatsoever that they do not fulfill on seniority.
Yes.
They are also being a given chance. Okay,
Yeah.
we are keeping 50% reserve, but you'll have to compete.
Yes.
Amongst each other.
Yes.
Then you pass.
Yes.
So ultimately, in this way, both of you reach the higher post.
Yes.
So I do not think this is a case of direct recruit and promote.
That's what I'm saying, Lordship. Because if there is, if your
This is
Lordship,
not a case,
yes,
because you are from the same.
yes,
cadre. This
if
is
your
not a
Lordship
case of-
holds this, that it is not a case of direct recruits and promotees, then we need not even go to Parmar or Megachandra and this and that, Lordship.
This is not a case of promote and direct recruit.
I'm saying
Anyway, this is the primary view. I try to understand what is the issue. Instead of spending so much of time,
yes,
let us. Okay, we'll go to that. This is the initial.
Yes.
Okay, start your argument. How
So,
much
Lord-
time will you take? Tell us. Half an hour?
Maybe half an hour, Lordship,
Half an hour, 45 minutes?
if we go through the judgments, if your Lordship wants.
No, we'll have
uh,
to hear because it's a
yes.
hearing matter. But
Yeah.
others are all are waiting. We do not know them. Future of others.
Let, Lordship may take their case first then, if they're not going to take much time.
Because these are order matters.
Yes.
We can finish it up and continue. If necessary, we'll continue tomorrow. I do not want to make things half-hearted.
Yes.
We'll complete. Hmm. Exhaustive from? But we have already spent almost half an hour, so we'll take it up tomorrow. Tomorrow is the best day, Tuesday.
Day after, if
Day
not
after.
tomorrow,
Day after.
day after.
Or we'll, okay, continue. We'll see later. Okay, proceed. Proceed. If he is, okay, proceed then.
2 days ago, the pumpkin comes again, both of us are to fix matter. Seriously.
Don't think that I have expressed my opinion.
No.
Just a in between line. Don't think that I am always open to the arguments. These are the preliminary, what is the case to understand, what is the issue, whether it's a directory case, directory promoting case, whether Parmar will be applicable or not. This is to understand this is, and in those deliberations, we express some views, but these are not the judgments. So don't be unwell immediately.
I was not,
No, I know that. These are all lighter statements. So now tell us what to do. Proceed today, tomorrow, day after tomorrow.
Since we are already in.
No, I will dictate in the court itself. That's all.
Day after.
Day after. Huh? Hard in part, list this matter for further hearing day after tomorrow. And I will need one thing.
Yes.
What is the separate facts of each of the cases?
It's almost the same.
Huh.
I will make a list of dates.
List of dates of each of the cases.
Yes.
Because legal issue is something we can adjust, but we'll have to pass a
So
comment.
far as the other two cases is concerned, the later one, I will try to club it together because there is hardly any effect. They have.
Just make a note.
Yes.
In the side.
Yes.
Okay.
But kindly, 7, please fix matter.
Okay. 8 is a Friday?
Thursday.
8. Okay. And where is the notification page?
Which notification, Lordship?
That 21 notification.
Oh, that is in their affidavit.
Page. We also do some homework. Huh? Page 34 and 37 of
Respondents 3 to 7. Affidavit of respondent 3 to 7.
3 to 7. Can you give me these two printout of these two judgments?
Yes, Lordship. I have it at the moment. I can give this one. In fact, I'll print it out later again.
You give these two, just keep in the file so that
What?
Give these two judgments here because this will be one of the bone of contention.
Yes.
These are 3 things. One is the
In
notification.
fact, I'm following their narrative. Otherwise, it's my submission that this need not be even gone into because they are not
Okay,
direct.
therefore, your first argument will be this is not a case of direct recruit and promoting.
Yes.
Moment it comes, we reject this contention,
Yeah.
then we'll come to the next.
Because the respondent authorities, they have applying Parmar's case rejected, have interpolated them in the seniority list. That is why. Oblige.
On 8, hard in part, listed for further hearing on 8.
May it please your lordships.
Yes.
I'm appearing
Yes,
online.
yes, state.
My lords, this is a very short petition, my lords. First, I'm praying for appointment of an arbitrator on behalf of the
What is their
respondent.
stand? Why so much of affidavit in for section 11 petition?
I'm so grateful, my lords. They have taken the stand that the matter is barred by limitation. I will just show two dates to your lordship, my lords. The matter is not barred by limitation. Then their other stand was that they need to show your documents in detail regarding the fact that the petitioner had not executed the project, etc. My lords, my humble submission, these are all issues to be
No,
looked
no,
at.
merit we cannot go.
Yes, my lords. I'm so
Sim-
grateful, my lords. I'm so
Simple
grateful.
issue is whether you
Yes,
have
ma'am.
demanded, arbitration clause is there, you have
Yes.
demanded or not. Of
Yes,
course,
ma'am.
limitation can be a question.
My lords, limitation, it is not barred by limitation. I'll just show two dates, my lord. One is, lordship may just kindly note, they terminated the project on 27/4/2021. Lordship may kindly note
27/4/2021 and
page 192 of the petition. That is the
192.
termination notice.
This is
Yes.
termination.
Yes, my lord. They terminated my contract.
27/4/2020, 2021.
2021.
And when you made the demand?
My lords, thereafter I had called them for mutual discussions as per the clause. That never took place. I invoked arbitration on 1/6/2023 within a period of 3 years, my lord. That's at 243, my lords.
That's
These are the only two documents.
And why they are saying barred by limitation?
My lords, they are saying that this project has been continuing from 2006. My lords, the fact of the matter is I could not execute.
No, the contract is, forget about the contract, date of the dispute arose on which date, the termination?
Yes,
Or
my
maybe
lord.
subsequent when you raise the dispute?
That is all, my lords. 27/4/21 and 1/6/23 when I invoked arbitration, my lords. By then the
Yes.
dispute had occurred. And my lords, parallelly in the same reply, they have suggested the names of 3 arbitrators, my lords.
No,
However,
come to that later on. Let us understand since otherwise a section 11 petition, we cannot go to all this, who is good, who is bad, who has done what, who has not. For that purpose, arbitration is
Yes,
there.
Madam.
This is not our business.
There is a arbitration clause that is accepted.
No dispute about
No
that.
dispute, Madam. Only thing is that whether there is a live issue to be arbitrated, to be
That
referred
is to be
for.
decided by the arbitrator.
My lord, that's why, my lord, because my lord will see the facts, my lord. 2006, the agreement was entered. The deadline was 2010, 4 years, my lord. Thereafter, it was extended for till 2012. Nothing done. They have not there as part.
Mr. Ratan.
Yes, my lord.
Just think of our power under section 11.
Exactly, my lord.
We cannot
only
see
do that first.
that state, they are very bad contractor, they have not executed, we have had so much of loss, file a counterclaim.
Exactly, my
Go
lord.
to the arbitrator we are appointing right now, tell us the name.
so grateful, my lords. In fact, I've submitted the panel of
My
this
lord, in
Honorable High
fact,
Court.
if my lord, I can
Claim, make a counterclaim against them, give us
I'm so
hundreds of
grateful.
thousands.
that
of
is there, my lord. We have a good case for counterclaim, my lord. But
your state have the scope.
my lord,
In the
state
arbitration.
will be directed to go for this arbitration proceeding, which is also a time-consuming and costly process, my lord.
But you have opted for arbitration.
My lord, we have
It's
denied,
contract.
my lord, because all
We have
this,
denied what?
in fact, arbitration, they have raised these disputes, which my lord will see what type of disputes also. Whether
Okay,
that
let us see. You say this is not an
arbitrable,
let us see.
yes, my lord.
What is your dispute? Let us see.
My lord will,
That again,
I'll
my
just
lord,
show
that again has, my
two,
lord,
three
please.
clauses. My
Tell
lord,
us show us the arbitration dispute, how it's raised.
my lord, I'll just show 2, 3 clauses, my lord, of the agreement, and then whether.
But please, Mr. Ratan, you are the representative
Yes, my
of the
lord.
state. Don't argue that
I'll,
they have violated clause.
No,
That
no, my
means
lord. No, I will not argue on
they
that.
have violated, they have not acted, we have given them contract, state has faces so much of losses, therefore we have to terminate, we have engaged
lord,
new contractor, there is an escalation. No.
No, my lord, I'm not on that.
Yes.
I'll not.
Yes, so as the,
My lord, the memorandum of agreement, my lord.
yes, page.
Page 70, my lord.
Page 17.
70
70.
of their
Yes.
petition, my lord. My lord, and then I'll directly take my lord to what the terms of at page 75, my lord.
Page 70, yes.
General terms and condition of agreement. The state hereby grants permission to the company so and so to undertake preliminary investigation to preparation of pre-feasibility report, detailed investigation for DPR preparation and subsequent implementation, operation and maintenance of Nyang HEP in West Siang District, Arunachal Pradesh.
Arbitration and Conciliation
Yes,
Act,
ma'am.
1996.
The
Yes.
project shall be implemented by MSDS Construction Limited on boot, build, own, operate, and transfer for a lease period of 40 years from the commencement commercial operation date. The project shall be reverted to the
Arbitration and
state
Conciliation
on
Act,
expiry of 40
1990.
years, free of cost, in good working condition. No extension of lease period will be considered on expiry of the lease period of 40 years. The entire cost of investigation, DPR preparation, project implementation, and subsequent operation and maintenance of the project will be borne by MS so and so. DPR, everything.
Okay,
they'll-
okay. This is a BOO.
Yes, my lord.
BOO project.
Yes, my lord. And then, my lord, then, my lord, I'll skip the others, my lord. The relevant clause 2.6, my lord, it is not that clear, but all the clearance of as required
From
from
central government in connection with the
project implementation shall be
shall be
arranged
arranged
by
by the
the
company
company itself. Yes. The state government shall accord necessary clearances under its preview with a reasonable period. The state government shall extend all needs and best assistance in obtaining such clearances, including licenses, approval, so and so, so and so. This is first, all clearances has to be first, they have to obtain. Statutory clearances, madam. This, the state will help whatever it is feasible, madam.
Okay.
Then my lord will come, my lord. At close 3.1 at page 78, my lord.
78.
Yes, ma'am. Well, my lord, I'll skip this also. It's for acquisition, my lord. And then my lord, page 82.
Yes.
82.
Page 82.
12.1, my lord. How, my lord?
12.1.
Yes, ma'am. The company shall achieve the financial closure within a period of 12 months from the date of receipt of techno-economical clearance, TEC from Central Electricity Authority, approved by the Ministry of Environment and Forest and other statutory clearances. In the event that it is confirmed as impossible or impractical to achieve financial closure, or if the financial closure is not achieved on or before the expiry of 12 months from the aforesaid date for the reasons other than those attributed to the government of Arunachal Pradesh, the Arunachal government reserves the right to terminate the agreement. And then, my lord, further, in the event of stoppage of construction of the works of the project by the company for a fixed period for more than 12 months for reasons not covered under force majeure so and so, for reasons attributed to the company and or abandonment of the project by the company, the state shall, after giving due opportunity to the company to resume the work, have the right to terminate the agreement. In the event of termination of the agreement under the clause, the government of Arunachal shall have the right to take over the project on as is where is basis, and no claim of the company shall be entertained. The government of Arunachal Pradesh shall have the exclusive right to reallot the project to any other company. Then, my lord, 12.3, my lord.
In case the company does not commence the implementation of the project period within a period of 4 years from the date of signing of this agreement, or within a period of 1 year from the date of receipt of statutory clearance such as environment, forest and environment, techno-economical clearance, etc., whichever is later, the project shall be reverted to the state government on as is various basis, along with the reports, other documents, etc., free of cost. However, the above time period shall be automatically extended by aggregate of the period during which the company could not take steps to the commencement of implementation by reasons of force majeure conditions. Thereafter, the state government shall have the exclusive right to re-allot the project to any third party for further development of the project. The company, if interested on its own, may take necessary steps for reimbursement of its expenditure from such third party without the involvement of the state government. Now, my lord, here, facts, my lord. Then the third.
See, I will come to your facts. Your case is that they were supposed to comply with these clauses.
Yes.
That you have referred. They have miserably failed. Therefore, under the clause, we have taken it over. We have done it to somebody else, whatsoever. So therefore, they don't have any claim. Okay. Now, if you see, so therefore, this is your case is that we have rightly terminated the contract for violations of the terms of the contract. Yes. Okay. Their claim is that, see, we were entitled, there is no illegality on our part for termination. Therefore, compensate us. Okay. This is the case. So therefore,
yeah, my lord, I understand
therefore, it is not we to decide whether there was force majeure, whether they could complete the project with time, whether it was 90 days or not. It is not the business of a court exercising power under section 11.
No, my lord, I'm not on that. What I'm saying, my lord, project, it was supposed to be completed in 2010, within 4 years, 2010. It was extended. Thereafter,
why did you not terminate the contract and
wait
till 2021?
My lord, that is there on the part of
if that is there, limitation will start from the termination of the contract for arbitration.
The claim they are now raising is that because of the non-cooperation of the state government, which they are saying
they will have to prove it in the arbitration proceeding. Now, for your like custodial approach, if they win the arbitration, you will have to pay interest for all this, because limitation will not start from that day according to you, which you have said that they have not done. What prevented you to terminate till 2021?
There is there, my lord.
If that is there, we'll have to pass this order. Given it.
But
given it.
In that event, my lord, as per our affidavit, my lord, what they have suggested, my lord.
What they have suggested, tell us.
Otherwise, I was
yeah, had it been a
Justice Indu Malhotra, my lord. Indu Malhotra.
What is the place of arbitration?
Guwahati, my lords. And as, my lords, there is a notification, my lords, I filed it on the record dated 21st.
No, that we know, that the names of the arbitrators.
Yes, my lords. Lordship may consider from that list of this Honorable High Court, my lords.
Because it will be difficult on everybody's part, going to Delhi, doing arbitration, or bringing arbitrator to Guwahati or place there, they can very well decide later on also.
We have actually.
My lord, I think this is the latest list of arbitrators.
21-5.
Yes,
yes, my lord.
21-5-24.
21-5-24, my lord.
Can you have a consent of Mr. H.N. Sharma over telephone? Telephonic consent.
My lords, we have nominated an honorable retired judge of the Supreme Court. My lords, would your lordship consider nominating on their behalf an honorable retired judge of the Supreme Court of this honorable court?
What is
Subject
the, what is the, this, how many arbitrators should be there?
Tripartite, my lords. We have nominated one. Lordship may appoint
No,
on
no,
their
let us
behalf.
see the arbitration clause. Yes.
Lordship, at page 83, my lords.
Where is that provision?
13.1. In the event of any difference or dispute between the parties, the same shall be resolved in accordance with the provisions of the Arbitration and Conciliation Act, unless the same has not been resolved amicably by mutual consultations within 90 days before the reference of dispute by either party. This chapter is over. The venue of the arbitration shall be Guwahati. The language of the arbitration shall be English. Costs shall be shared equally. In the event of any litigation, Guwahati High Court shall have the sole jurisdiction. That is the clause.
That constitute total how that there should be 3 numbers or any.
My lords, my lords, both parties are ad item that they want a 3-member tribunal, my lords. In his own reply at page
The
28.
3-member tribunals, who will be the tribunal members?
I have in my arbitration notice appointed the Honorable Mr. Justice A.K. Sikri, and I am praying for appointment of an arbitrator on behalf of the respondents, my lords. That is the petition before your lordship. So therefore,
you have already proposed them, but that is not binding upon us.
I'm praying that your lordship will consider
And
the
what is
value.
your
My lord, in our affidavit, page 26, my lord, in
Page
alternative,
26 of?
our affidavit.
Page 26 of your affidavit.
Second para, my lord.
Page 26.
Page 26.
Second paragraph.
Yes, my lord. They have given 3 names, my lord.
Justice Indu Malhotra, Justice Vinit Saran, and Justice Vikramjit Singh.
There is no Singh, my lords. There is no Justice Vikramjit Singh, my lords. That's a wrong thing.
Oh, but this is by the affidavit.
There is only
Vikramjit
Justice.
Banerjee, is that it?
It's actually Vikramjit Sen, my lords.
Sen.
S-E-N.
Sen.
The Vikramjit Banerjee is someone else, man.
So there is no specification that there should be some technical members, there will be
No,
one
nothing of that
arbitrator,
sort,
2
my lords.
technical members.
Nothing of that sort. We are, in fact, both parties are seeking the appointment of a tripartite tribunal. Lordship may therefore kindly appoint on their behalf, my lord.
Where is their, but their thing is not tripartite. They say alternatively, without any.
In fact, no, they are saying, my lords, that they.
No, we are
that
also
the
opposed to
petitioner
one
was-
member tribunal.
You oppose one
Yes, my
member.
lord. As for this
They
affidavit,
want a
my lord.
tribunal also.
Then if there are 2 members,
And they in turn will appoint the 3rd, my lord.
My lord, as per their suggestion, there one.
if there are 2 members, there will be require an umpire, third member, isn't it?
My lord.
You will require a third member.
Yes, my lord.
To
So-
be appointed by these 2 arbitrators.
Yes, absolutely, my lord. Yes, my lord. Yes, my lord. So today only, your lordship may only
No, we understand. We'll give
on-
that portion, the rest that 2 arbitrators will
Yes,
do.
my lord.
Yes, ma'am.
Otherwise, we'll come back to your lordship.
No, that we understand, but
Yes.
there are some, this is how state responds to it. I think we should give them 1 day's time. We can pass this order tomorrow.
Yes.
Since they have filed an affidavit. Tentatively, our view is that a case for arbitration is made out. Disputes, we cannot develop in this petition. There are a individual proposal from a special proposal from their side. Though you have given some proposal, there may be change of situation from the state.
Yes, ma'am.
Instead of conceding, because there is not clear admission, but state's position is that we want a 3-member arbitration.
Yes, my lord. Both parties are clear, my lords. Therefore, we would-
3 members arbitral tribunal, 1 each will be appointed by each, and other is
By the arbitrators.
But there are some issues. It is a cost involved things.
My lords,
Your proposal is that those people will have to see We'll have to think while sitting in a bench in a state like Arunachal.
My lords,
Those
may I
things
say,
are there.
may I only say one thing, my lords? May I only say one thing? We have
Just slap
sought,
this instruction.
Yes,
my
my
lords,
lord. I'll have
Party, two arbitrators, third, then everything is there.
my lords, may I
I'll
only,
have-
may I make only one submission, my lords? We have, both parties are, requesting a tripartite tribunal, my lords, because the claim value is slightly large,
No,
my
I
lords.
understand. Where is it?
Right.
Where is just highlight the statement in the affidavit that in the event arbitration is there, they want tripartite. Where is that?
That is,
And your statement.
Our statement is at page 26, my lord. It's
26, my
second
lord.
para
So-
of para 12.
26.
Page 26 of
Yes,
Our affidavit, my lord.
your
Of-
affidavit.
the state's
It is the
reply.
second para of para 12.
Kindly see that, my lords. It is stated
Just a
deponent is,
minute, paragraph 12.
12, second para of para 12.
yes, my lord,
Sub-para of para 12.
second paragraph of paragraph 12. That, so this affidavit, my lords, if I may just say, they have taken time, they've sought instructions, they've sought an adjournment, and then they have filed a detailed reply, my lords, by the executive engineer. After taking instructions of the government, my lords, in this paragraph, he has said, deponent has always opposed the one-member tribunal, communicated the same to the petitioner. Petitioner was adamant for one member, thus nothing could move forward. So the respondent suggested alternate so-and-so, etc. So therefore, my lords, we are praying for a tripartite tribunal, my lords.
Just listen to me. We are fixing this matter tomorrow. Just listen to the order. For final delivery of order. Okay. Heard, you are Mr.
Manu Seshadri, my lords.
Manu
Manu
Seshadri, learned counsel for the petitioner. Also, Mr. Ratan, learned additional advocate general, state of Arunachal project. The present application is filed. Filed under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 for appointment of arbitrator arising out of a contract dated arising out of the subject contract which was terminated on 27/4/2021. Full stop. It is the case of the petitioner that even after the demand of arbitration in terms of the arbitration clause made on 1/6/2023, while no arbitrators were appointed, the present petition was filed. Full stop. Detailed affidavit has been filed by the state touching the merit of the claim of the petitioner. However, after perusal of the pleadings, this court is of the view that the petitioner has been able to make out a case for appointment of an arbitration, though a question of limitation has been issued. Full stop. In the considered opinion of this court, the claim appointment of arbitrator is not, the present application is not barred by the limitation in as much as the contract was terminated on 27/4/2021 and a demand of arbitration was made on 1/6/2023 and thereafter the present application was filed on demand was made filed on 29/7/2024. Full stop. However, which will be dealt elaborately tomorrow. This case is adjourned today. You can argue still tomorrow regarding limitation. Okay. This matter is fixed tomorrow. In view of the fact that in the event this court decides to appoint an arbitrator, there is no clarity from the respondent state as regards the appointment, dear choice of arbitrator, though the petitioner has proposed a name of arbitrator. Full stop. It is also to be noted that the respondent state has taken a stand that in the event arbitrator arbitration tribunal is appointed, the tribunal should not be single-man tribunal, but should consist of two arbitrators, each from each side. Full stop. In the aforesaid backdrop, Mr. Ratan, learned counsel, submits that he may be allowed to have instruction as regards any choice of arbitrator in the event this court appoints some arbitrator. List this matter tomorrow.
Grateful, my
We'll
lord.
just have it and we'll give him a chance to argue on the limitation.
Very well, my lord.
Because see, that is a height that can be taken in 11.6, not the other methods.
Yes, ma'am.
So you come prepared on limitation where you're saying limitation.
Limitation, my lord, that is the, my lord, my argument was on the live issue, my lord. Live issue.
No, limitation to
Lordship, I recall
limitation-
he's giving it up.
limitation for the claim.
Claim, my lord.
Okay,
Yes.
limitation for the claim. You argue it, we'll
Yes.
deal it tomorrow.
Yeah.
I'll giving you a chance.
Yes, ma'am.
You will also hear him on the limitation because we have not gone through the details of the pages. And we
Yes.
do not want to cut short for this point for tomorrow.
Yes,
Because we know with this point will be necessary to be dealt with. Then tomorrow we'll seek that I want instruction.
Yes.
Would your lordship record that he's given up limitation, my lord?
No, he has said that he will argue on limitation. Let us have the
Yes.
limitation point argued tomorrow.
Yes.
Okay, that's the order. So let us see.
Yes, ma'am.
Your thing is that it's long back it was done.
Yes.
But problem is that you have terminated the contract.
Yes, my lord.
So
Yes.
his cause of action to claim was not arose. He was hoping that you will not do something, terminate contract is not terminated.
Yes.
That
Obliged.
other things you can raise in the arbitration. List tomorrow.
Obliged.
Grateful. Grateful.
Let
Item
me
number?
note. Well, item number 20.
Orders are over. Huh? Others are over. Is that Mr. Singh's case?
Yes.
Okay. Okay.
Well, item number 20, 27, and 28 are similar, my lord.
20,
27 and 28 are similar to item 20, my lord.
29,
No, 27, 28 only. 29 not similar, different, my lord.
26 and 27. Okay.
No, my lord, 27 and 28.
Now they have given item 20. 20.
20 lordship is taking up now.
20.
Now 27 and 28 may be taken up together with 20.
27 and 28.
My lord.
Okay, Manav Jyoti Gogol. What is your case?
Basically, my lord, we have come here for, my lord, we were declared L1, my lord. Therefore, they were finalizing the tender. So we approached the honorable
What
court.
about the affidavit?
They have not filed.
I'm appealing on behalf of M. Kato, Lord.
There is an interim order.
My lord.
An affidavit is required.
Yes,
We are not saying that you are not powerless to terminate. But in a given facts, when price bid is open, what stopped you? What the good reason that you have taken these things we want to know? And in the meantime, a public project is state.
Yes, ma'am.
Immediately file affidavit.
Yes, my lord.
When?
My lord, 3 weeks coming again.
No 3 weeks. Hardly 5 days time.
Sorry, my lord.
Hardly 5 days time. Or if there is delay and after thereafter, if we dismiss this writ petition, then for this delay, the officer will have to pay cost. And if we allow this writ petition, then the price escalation for this delay will have to be paid by the officer who is responsible to file this.
We'll take
affidavit.
instruction, Lord. Definitely.
Public, state, etc.
Definitely.
And item number 27, there is an interim till today, my lord. It may be extended.
প্রথমত লেখক item number 20 লিখব list this matter along with WPC 267/2024 and 254/2024. Okay. The learned state council submits that he may be granted 2 weeks time, 2 weeks time to file affidavit. Prayer is allowed. The matter involves execution of a public project and there is an interim order. Full stop. Therefore, this court shall expect that the affidavit shall be filed within 2 weeks. Full stop. within 2 weeks. List this matter on. Third week, it should be filed within 2 weeks. I.e., give a date within 2 weeks. So when 2 weeks will be over from today? Finish, sir. 2 weeks will be over when?
It will be over 19/8.
Huh?
19/8 it will be over.
19?
It will be over.
It will be over.
Over.
On or before 28th of August 2024. Full stop. Hereafter, list this matter on.
Can it be on 29th of August?
29th of August 2024. In the meantime, if affidavit, comma, in the meantime, comma, if affidavit is filed, the petitioner may file a reply. Full stop. Interim order passed in this batch of petitions, if any, shall continue till 29/8/2020.
My lord, item number 20 and item number 28, interim is until further orders, my lord. In only item number 27.
That's why I say interim order pass,
my lord,
if any.
my lord.
That's why I have given a
My lord.
common order in all
My
cases.
lord, I can seek one more observation, my lord.
Yes.
If the wish machine during the pendency of petition shall not be a bar, consider my bid made. That may consider also, my lord.
We'll do that on the next day.
Oblige, your lordship.
It is needless to say that, no, we'll not proceed it because they have taken a decision. Why should we make an observation? Yes.
Oblige, your lordship.
No steps has yet been taken for service of notice upon respondent number 5 by paper for application. First up, who is respondent number 5? Any interim order?
No, Your Lordship.
None appears for the petitioner. None appears for the petitioner on call. However, in the interest of justice, matter stands adjourned. Matter stands adjourned for 6 weeks.
My lord,
Just a minute. Yes.
my lord, I'm appearing on behalf of Opada. And my lord, were for the petitioner. My lord, actually, my lord, this matter has been infectious.
Infectious?
Yes, my lord.
Mr. Your name?
D. Pangu.
D.
Pangu.
Pangu. Learned counsel appearing all on behalf of
Opada.
Opada. Learned counsel submits that he has that this petition has become infectious. Accordingly, the petition stands closed being infectious.
Item number, lordship, 20, 27, 28, lordship has fixed on 29th of August. Can it be on 2nd of September, lordship?
Okay, you inform the others.
I think he's there. Lord.
Okay, 2nd of September.
Deeply appraised.
Then we'll give an affidavit, 1 week more to file affidavit.
Fine.
Accordingly. 3 weeks to affidavit, then 29, 2nd of September.
Deeply
May I, Your Lordship?
Yes.
Your Lordship, this matter may be listed day
Listed
after
for what?
tomorrow, Your Lordship.
Listed when?
Actually, in this matter, Your Lordship, our AH,
No affidavit
number
filed.
is appearing.
No affidavit file.
Yes, Your Lordship, we have filed our counter affidavit for respondent number 1 to
Who is
8.
respondent number 9 and 14?
Yes.
You want to file affidavit?
Yes.
Or you have filed it?
No.
No. And state? No.
We have filed, Your Lordship.
You have filed.
Yes, Your Lordship.
So you want to file affidavit?
Yes.
Mr. Omo.
Yes.
Learned counsel representing respondent number 19 and 14 submits that he may be granted 3 weeks time to file a affidavit in opposition. Full stop. Prayer is allowed.
Lordship,
Please, this
interim
matter
may be
after
continued.
3 weeks interim order pass earlier shall continue till the next date of listing. All right. Yes, what is this?
The state was required to file affidavit by my lord. By Friday, my lord, last Friday.
Yes, rural works department.
My lord, main council is out of station, my lord.
Uh-huh.
Council is out of station, my lord.
The council may be out of station, officers are not,
Yes.
isn't it? Affidavit will be filed, okay.
My lord,
24 matters will give some time.
I have one prayer. I may be allowed to assess the postal receipt. Steps taken upon the private respondent. Because private respondent 7, they are appearing. Private respondent 8, I want to see, my lord.
Okay.
The status.
Service report in respect of 7 and 8 are still awaited.
My lord, 7, they are appearing.
I'm appearing for
7 is there. What about 8?
8, that's why, my lord, postal receipt, I may be allowed to assess the postal receipt so that I can get the status of my service, my lord.
Okay, okay. Service is complete in respect of respondent number 7, NMS T. Bhutia. T.Y. Bhutia, learned counsel is present representing the said respondent. Full stop. Service report of the respondent number 8 are still awaited. Accordingly, the learned counsel for the petitioner submits that he may be allowed to have an access to the postal receipt, so that he can track and get a report from the postal department.
Yes, ma'am.
Prayer is allowed. Prayer is allowed. Why don't you take a first steps?
My lord, this address is from Assam, my lord. It will be, again, there will be delay, my lord, because register for, it takes time, my lord. So I will get the status report, my lord.
Okay. The status report also remains for some limited period only.
No, my lord,
It remains.
it remains.
Okay. And thereafter, he may submit such a report if available before the registry.
Our state has to file, my lord. Maybe it
No,
may be
no,
listed
that
on
report.
report, my lord. If it can be listed on 14, my lord, I will file my
Not
report by 12.
I'm saying about that postal report.
Postal receipt, I can collect it from, my lord.
No,
And-
you have the number.
Yes, my
We
lord.
are giving you not to take the postal receipt.
My lord.
We are giving you to
The
have
number.
an access to the postal receipt.
Yes, my lord.
So that you can have the number and track it.
Yes, my lord. There is a
Isn't it?
portal, my lord. I can
Huh?
collect it, my lord. In the internet, there is a
We
portal.
understand.
Yes.
So we passed an order. If any report is received, he may produce it before the.
Yes, my lord. I will file an affidavit, my lord.
By way of an affidavit.
Yes, my lord.
Okay. MS Bhutia, learned counsel, as well as the counsels for the rural works department. Pray for and are granted.
My lord, can
3 weeks time, 4 weeks time.
My lord, 2 weeks.
Service is not complete.
I will submit the
3
report
weeks
by
time to
12.
file affidavit in office. You'll have to believe that, na?
My lord. Oh, bless.
My lord,
What is this IA?
this I is relating to perjury committed by respondent number 2, 1, 2, 3, and 6. Ma'am. And they have committed the offense while replying the paragraphs of the writ petition. Ma'am. In that affidavit in opposition, in paragraph 5, they have said something which is not true. Paragraph 5, my lord.
Okay. The present application is filed under section 340 rate with. When did you file this petition?
Writ petition, my lord.
It cannot be. It cannot be. It was filed on 3rd of August. You cannot file under CRPC.
The writ petition was filed.
There cannot be read with. One is dead already.
But I have mentioned.
One is surviving, you have, at least you have said that read it. We'll have to delete the first part.
Okay,
We'll issue a notice, we'll fixing next week.
yes.
Because we'll have to have the response. So we are passing this order. The learned counsel for the petitioner submits that inadvertently, provision of Criminal Procedure Code 1973 has been mentioned. Provision of Criminal Procedure Code 1973 within bracket since repealed has been mentioned in the cause title. Though the petition was filed on 3rd of August 2024. Accordingly, he phrased that he may be allowed to correct the cause title.
My lord, instead of allow me to making correction, then can it be strike out?
Now it is not possible. There is a notification. Otherwise, we used to do. What we will have to do, you need not change this. I'm telling you. Correct this cause title as prescribed under notification number dash 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 of dash dash dash. I'll just be later on code it. As per that notification, you will have to correct it. Give a printout to the registry will replace it. That's all.
All right.
Now, no separate whole petition is required. Only cause title portion. Okay. The first 2 pages you will do it.
All right. I'll do it.
Or even the first pages, you can manage the paginess.
Okay,
That's
I'll
all.
do it.
After registry to do the needful in this regard, list this matter next Monday.
By next week.
Next Monday. List this matter next Monday with the date. Okay.
All right.
We'll issue a notice, then they let them respond. Private service report in respect of respondent number 8, full stop. Other respondents may complete their instruction and may file affidavit of apology. List after 3 weeks.
This matter will be released day after tomorrow, my lord.
Huh?
Day after tomorrow, my lord.
What is the stand of the respondent? You are not aware.
My lord.
On the prayer of the learned counsel for the petitioner.
Yes.
List this matter on
6th, my lord.
6th of
This morning, my lord.
okay. 6th is tomorrow.
Oh, sorry, 7th, then.
7th. Anything survives?
Sorry, my lord.
Anything survives in this petition?
Lordship, this matter, Lordship, I made a party, Lordship.
Who are you?
I'm for private respondent, Lordship, respondent for Lordship. No prayer against me, Lordship. Unnecessarily, Lordship.
There was an advertisement.
I'm sorry.
At last occasion, Lordship, the petitioner counsel sought for a time for taking to take the instruction from their clients whether to proceed this matter or not.
That's
I'm sorry, my lord. My dealing main counsel is let the premises for urgent.
Let us do one thing. Who is the main counsel?
M. Kato.
M?
M. Kato. Mato Kato.
M. Kato.
Yes, my lord.
Your name is there?
No, my lord. I'm appearing on his behalf, my lord.
Then we'll dismiss it for default. Let the communication go to the client and then let them say, Mr. Kato, that something. There is an advertisement of challenge of which year?
Lordship, 2018, Lordship, advertising.
Then what happened to the representation?
Lordship, and government was instructed to whether this advertisement is completed, process was completed or not.
No,
The
yes.
instruction was
But
sought
if-
from the government, Your Lordship.
Who is representing government?
Lordship,
Now, there was an advertisement, he challenges, there is no stay order.
Yes.
And his case was that his case should be authorities considered, will dispose it of
Yes, Lordship.
for consideration, file a fresh representation.
Yes, Lordship.
Please this matter tomorrow again. In the meantime, the parties may obtain instruction in terms of this court's order dated 24/4/2018. Tomorrow. Yes.
My lord, may kindly come to page 43, my lord.
Page
43. The tender doc-
43, tender document.
It starts with e-tendering, e-procurement,
Page 43.
43.
Yes. Food Corporation of India, regional representation.
My lord, before e-procurement, earlier the tender used to be in the hard copy. They had to submit. Now, after this e-procurement, they had to submit after signing the this tender document online, my lord. My lord, may kindly come to page 47.
Page 47.
What is the
Yes.
point of the relevant?
Yes.
Clause 6, that is earnest money, 3 lakhs. something.
Page clause 6, earnest money.
This earnest money has been exempted since the petitioner was MSME contractor, registered under the MSME.
Okay.
Then security deposit, clause 7, when the security deposit has to be submitted, my lord, the successful tender shall furnish within 15 working days of the acceptance of his tender. Then again, down below clause 2, in case of failure of the tender to deposit the bank.
Just clause 2.
Clause 2, in case of the failure to tender the deposit bank guarantee as stipulated in clause 7, 1, B and C, within 15 working days of acceptance of his tender, further extension of 15 working days can be given subject to levy of penalty of 1% of the whole amount of the security deposit. And then another 15 working days will with levy of penalty of 2%. So the date may be extended for filing for submitting SD or bank guarantee. Now, next page, my lord, page 48, submission of tender. The tender shall be submitted online in 2 parts, technical bid and price.
Page?
Page 48, my lord.
I'm at page 48. Where do we get? Continuous. After completion of prescribed period. Where do we ready?
Page 48, my lord, clause 8, submission of tender.
Submission of tender. Okay.
The tender shall be submitted online in 2 parts, technical bid and price bid. So this tender document consists of technical bid and price. Now, E, my lord.
This is my case, my lord. This is.
Yes, I'm coming. Tenders should be uploaded, submitted through e-procurement at so-and-so site. So first of all, they have to submit it.
Manual. Manual also given.
Manual bid, hard copy of the tender document will not be accepted. However, the successful tenderer will have to submit the original hard copy of MTF duly signed on each page of MTF along with annexures, appendices duly attested on or before the date and time of stipulated by the FCI, failing which the EMT furnished by the bidder is liable to be forfeited, and further that the award of contract through the letter of acceptance will be issued to the successful tenderer only after he fulfills this requirement.
So
now the opening of tenders, now the next page, my lord, page 49. Clause
Here,
14.
my lord has
Let's
kindly
start.
note.
Take your seat, Mr. Soikia. We'll hear you.
Clause 14, terms for micro and small enterprises.
Terms of migration.
The tender document cost will not be charged. MSME registered with the agencies of the terms of tenders exempted from the payment of earnest. Now, my lord, down below clause number 7 of clause 14. If
Clause number
7.
7.
If after award of contract, MSME resigns to accept the offer, then the corporation along with taking other actions allowed under the different clauses will take up the MSME authorities for cancellation of their license. Apart from taking actions as per this MTF, we will write to the MSME authorities to cancel the.
Now, what are the actions you can take? Whether that action includes risk and cost?
No, I'm coming.
Yes.
Now again, page 52, my lord.
Page 52.
Page 52, clause E. It is under clause 9, my lord,
Just a minute.
security deposit.
Just a minute. Clause E.
My lord may kindly come to page 51 first.
51.
Security deposit, 51.
Just a minute. 51.
A, the successful tender shall furnish within 15 working days of the acceptance
Just
of
a
its
minute. A of which clause?
clause 9, my lord, security deposit.
Clause 9 security deposit.
The
Okay.
successful tender shall furnish within 15 working days of acceptance of his tender a security deposit for the due, proper and complete discharge of their obligations under the contract. So, my lord, E, next page 52E. In the event.
Just a minute. Just. Was it deposited in this case?
No, he has not deposited. He in fact resigned.
Okay. Then
Page 52, clause E. In the event of the tenderer failure after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a) by due date or requisite security deposit in the form of bank guarantee under 7(1)(b) that I have read, my lord, including extension period, his contract shall summarily terminated besides forfeiture of earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation of such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and the law. The contractor will also be debarred from the participating.
Just a minute.
The contractor will also be debarred from participating in any future tenders of the corporation for a period of 3 years, my lord. So we have invoked clause 9E, my lord. Now, my lord, let us come to the letter of acceptance.
Just a minute. So what is the procedure? First tender is there, except then
He has come out successfully. His price rate was low.
Just no, under this e-tender is there. Then after e-tender, he will have to sign the hard copy and submit it.
Submit the through online, my lord.
No, first online.
First online.
Same he will have to download or whatsoever. Then the
then
scan
you have to
copies
sign.
everyone sign and given.
Yes.
Then thereafter tender evaluation is done.
The one who will be the successful tender, we will call for him and to submit the hard copy also.
Only to the successful
So
tender,
only to the successful.
not others.
Not others.
So successful tenderer will sign the hard copies and give it to you.
No, success already he has signed. We have
No,
asked them to submit.
we are not coming to his specs. We are coming to your procedure prescribed.
Yes, ma'am.
So tender, e-tender, then after successful, who is declared to be successful, he will have to sign the tender documents and give it to.
We have asked for submitting the SD.
It will give it, and at the same time, it is to be security deposit is to be given in other cases, in not the MSCB.
No, he has to submit. Security deposit bank. Only the EMD he has not.
Okay. So security and bank guarantee.
Yes.
Now, after security and bank guarantee, what is the stage next?
No, by issuing the letter, it was his offer. Now we have accepted it since he was the lowest bid. Now my case is the contract has concluded by issuance of the letter of acceptance. Through this letter of acceptance, we have asked him to kindly submit SD and BG along with your hard copy. Page 74, madam. The letter of acceptance was issued.
Okay. Now where is the termination of the?
My lord, first of all, the letter of acceptance, my lord.
Okay. Yes. Where is the?
Page 74.
Page 74. Yes.
It has been issued to RG Enterprises on 23/8/2021. Please refer to.
Just a minute, huh? Just a minute. Letter of acceptance is which page?
Page 74, my lord. And after 3 series.
74. Just a minute. Okay, 74.
Subject letter of acceptance in respect of regular road transport contractor from Bhalukpur to Bomdila. Sir, please refer to the tender cited at reference for appointment for road transport contract from so-and-so to so-and-so on for 2 years through e-procurement portal. Now, down below in this connection, it is requested to furnish security deposit details as below. 1, 2, and 3, my lord. Next page, my lord, 75. The relevant portion I am showing, my lord.
Now, where is the scope of letter of appointment of contract? Which provision
Page
deals with?
75.
No, which provision of the contract deals with? Letter of appointment of issuance of appointment of contract?
Well, just may I read the 2 line, then I will again go back.
Okay, which one?
Page 75.
Huh.
In the event of tenderer's failure to deposit the prescribed security bank guarantee, down below, security bank guarantee within stipulated period, action shall be initiated as per the clauses of the MTF.
Okay, fine.
Further, the letter of appointment of the contractor will be issued only after fulfilling this requirement and confirmation of the bank guarantees. These instructions are without prejudice to any other terms and conditions of the MTF, etc.
Okay.
Next page, 76. This is the forwarding letter. 76. Please find enclosed here with the letter of acceptance. Next paragraph, further, you are hereby directed to submit the original hard copy of the MTF and all other supporting documents with due seal and signature, which has been uploaded in the e-procurement system.
This is the acceptance.
Yes, this is the forwarding letter of the acceptance email.
Okay.
We have asked him to.
Now, she has replied. So
Now, he has resided at page 79.
Page 79.
He has written nothing. No grievances, just he has shown his page 79 there, email 10 September 2021.
Okay.
To the Assistant General Manager contract by the proprietor RG Enterprises.
Then 80.
With reference to the above subject, I have the honor to state that due to unavoidable circumstances.
I have read it.
Yes, ma'am.
This is the
So we have issued the termination letter, page 80, my lord. 6/10/2021. The relevant portion is para 5 and 6.
So you have done under clause 9E.
Yes, my lord. 9E. That security deposit that which I have pointed out.
Just show me that that provision only.
That he has to submit it.
That letter of appointment to contractor.
Yes, my lord.
But after E, there is nothing. Signing of contract, where is that?
No, signing of the.
No, not signing, appointment, since here a word is used, letter of appointment.
Letter of acceptance only. Only we have written in our letter of acceptance that you will be appointed.
Any provision as regards that?
Yes.
That is what I want to know. Is there any provision in the contract? That they are after receipt, their appointment will be issued to the contractor and work will begin, contract will sign. Okay, fine. As per your contract, your whole argument is that we have a power to take the action at this stage because it's clearly stipulated.
Yes, ma'am.
This is your case. But for our understanding, we want to know what is the letter of appointment to the contractor. Any provision in the contract?
I have not found it because the provision says letter of acceptance only.
Okay.
And since he has offered, he was successful and we have assured the letter of
Yes,
acceptance.
Mr. Sika, you wanted to say
It has been
something?
concluded now.
I was saying that, madam, because this is not a concluded contract, my lord. My lord, assuming that, my lord, if the my lord, bid documents which I have submitted is a my lord, data contract, my lord, then also, my lord, the hard copies were never submitted to the authorities, my lord. The hard copies were asked to submit, my lord, only on the day.
No, just hard copies are supposed not given. But Where is the provision of but ultimately, even if hard copies is not given, you were,
Then, my lord, I will be not. My lord, it
your
will be
case
the
is
acceptance.
that when I have refused to give the hard copies,
Yes.
then what will happen? What the contract says, let us see.
Contract says, my lord, is data says, my lord, first, my lord, after my lord submission of the hard copies, my lord, then only the acceptance letter will be issued to me, my lord. My lord, just now he has read out the, my lord,
Which
the
one?
provisions, my lord. Close,
Where
my
your
lord.
statement that you have not submitted that portion?
My lord, because, my lord, the pursuant to the acceptance letter, my lord, because of the COVID situation, my lord, we are financially, my lord.
Okay.
My lord, that's why, my lord, we have said that, my lord.
See, you will have to take
No,
a
no.
stand
Yes, my lord.
either saying that under the scope of the contract or contract agreement, the risk and cost cannot be, clause 9E cannot be made applicable.
Yes, sir.
Your ground, as you have argued, maybe that see, after online tender, I have not even submitted my document, therefore, they could not have given me the acceptance letter.
My lord.
Therefore, their acceptance letter, I rightly refuse. That can be an argument. But if you say, no, I wanted to do, but for COVID, I cannot, that we cannot help you. That COVID we cannot consider. You will have to see the parameters within the contract, because law is well settled. When it's a realm of private contract under exceptional circumstances, arbitrariness and all, we cannot enter into this. First. Second is that whole argument of the whole ground of, I'll not say argument because he's supporting his decision. The decision is based on clause 9E. It says there is already stipulation that once we issue this, we can take these actions. That you have agreed. Your case is that I have not even signed this document. So therefore, where is your statement that I have not signed this document? And not submitted the hard copies. Where is your statement?
My lord, I was before that, my lord.
Yes.
Kindly again, my lord, read the, my lord, close, my lord.
Clause, which
Connected
clause?
close, my lord. Lord, will again come to page 48, my lord.
Yes.
Of my petition, my lord.
Hmm.
8, submission of the tenders, my lord. Clause 8, E, my lord.
Clause 8.
E, my lord.
Now I need a different color. Yes. Clause
8, E, my lord.
any blue or red, anything yellow, except green. Clause 8, yes.
May I read, my lord?
Yes.
Tender should be uploaded, submitted through e-procurement.
Clause 8, which part?
E, my lord.
Clause 8E, okay.
E, my lord.
Okay.
My lord, may I read from however, my lord.
Just a minute. Just read it. We have time.
Tender should be uploaded, submitted through e-procurement at such and such as manual bids. Hard copy of the tender documents will not be accepted, my lord. Now, my lord. However, the successful tenderer will have to submit the original hard copy of the MTF duly signed on each page of the MTF along with annexer appendices duly attested or on or before the date and time stipulated by the FCI. I have to, my lord, submit the hard copy. Failing which, my lord, there are two, my lord, contingencies, my lord. Failing which, EMD furnished by the bidder is liable to be forfeited. First condition, my lord, if after declaration
So two
of my
conditions, totally your EMD will be forfeited.
if after my successful declaration, my lord. Second, my
And
lord,
award of contract contractual letter of acceptance will be issued to the successful bidder only
further,
after
the award of the
fulfilling
contract
this requirement.
the letter of the acceptance will be issued to the successful bidder, to the successful tenderer only
what I am
after the
saying.
fulfills this requirement, my lord.
That is what I am saying. According to them, you have submitted hard copy, so therefore they have given it to you. Your case is that I have not
Yes,
submitted. Where is your statement in the writ petition?
my,
And how they have replied to it?
my lord, my entire case is based on that, my lord.
Yes, this was the statement. I understand your argument. Your argument is that all these letter of acceptance you have issued on your own, I cannot be faulted with. Because after that, so you cannot say my participation was complete. This is your argument. According to you, my participation was not complete on the date of the things. Now, since this was the statement that
They've stated in paragraph 9. of their-
paragraph 9.
Page 21.
Paragraph page 18.
So 21 of their writ petition.
Page 9 start, paragraph 9
No,
start.
paragraph 9. Yes, paragraph 9 starts at
18.
page 18.
Okay.
Yes, my lord, 18.
Now
Relevant part,
I should be at page
21, my lord.
21.
It is pertinent to mention hearing. Ought to have asked for the original hard copy of the MTF and all other supporting documents of the petitioner's MSME form prior to issuance of letter of acceptance.
And what is your response to that? He has
My lord-
signed and
my lord, in
submitted.
my affidavit in opposition, para 11.
Para?
Para 11. Page 9.
Para 11, page 9.
Page 9. Then specific denial, my lord, at page 10. Therefore, the plea taken again and again by the petitioner that due to her non-presence during opening of technical bid as well.
Where are you reading? Therefore, the
Page
plea.
10. Page 10.
Page 10.
Yes.
Therefore, the plea.
Therefore, the plea taken again and again by the petitioner that due to her non-presence during opening of technical bid as well as price bid in the said tender, the tender should have been accepted as vague and baseless. Further, clause 80, my reply, my lord, of the MTF general information of tender, it gives absolute liberty to the corporation for asking the original hard copies of the tender documents as per the date and time stipulated by the FCI. That is in the in my letter of acceptance. And again, I will come back to the clause 80.
Further, the gives absolute liberty corporation to asking for the original hard copy as per date and time stipulated by FCI. Okay.
My lord, again, I will take your lordship to clause 8E, my lord.
Yes.
Page 48.
48. That we have read.
Or before the date and time stipulated by the FCI. So we have been given liberty when to ask.
Okay, where is your time stipulated? Stipulated time to give this document.
Yes, when I have issued a letter of acceptance.
Where is that you have said that you will have to sign this?
In my letter of acceptance.
Where is that? Page.
He has already signed it, my lord. He has to submit it now. Hard copy, my lord. Page 74. Relevant part is 75.
Relevant part is 70.
Last paragraph. Further, the letter of appointment to the contractor will be issued only after fulfilling this requirement. And this requirement means submitting all this SD and bank guarantee.
No, after fulfilling requirement and confirmation of bank guarantee. What is the
yes,
date?
in my forwarding letter, page 76. Please find enclosed here with the letter of acceptance. Then next paragraph, further, you are hereby directed to submit the original hard copy of the MTF and all other supporting documents with due seal and signature which has been uploaded in the e-procurement system during the participation of the.
So you want to say that FCI without verifying the hard copy?
No, it was verified, my lord.
No,
In
you
the
have,
technical bid.
you have verified in a e-bid. It was a scanned copy.
Yes, my lord.
So you want to propose that FCI without verification of the hard copy, where is that clause? Hard copy uploading clause? Where
Yes,
is that?
again, my lord.
Hard copy uploading submission of tender.
Page 48, madam.
Page 48, submission of tender. The tender shall be submitted online in two parts, technical bid and price bid. Technical bid consists of all these papers, my lord, the signed MTF. The all supporting document except tender document have to be scanned and uploaded in a technical bid, price bid, so and so. The envelope packet online should consist of this. Tender which do not comply with these instructions shall be summarily rejected. Tenders should be uploaded, submitted through e-procurement at so and so. Manual bids, hard copy of the tender documents will not be accepted. However, the successful tenderer will have to submit the original hard copy or MTF duly signed on each page of the MTF along with annexes, appendices duly attested on or before the date and time stipulated by the FCI, comma, failing which the EMD furnished by the bidder is
That's all what you can do. EMD forfeit, you can do EMD forfeit if it is not given in date and time. Violation of this clause, even if saying that this is the date, that gives you the power.
And further, that the award of the contract through the letter of acceptance will be issued to the successful tender only after he fulfills his requirement. Then again, the next, my lord, the security deposit. If he fails to deposit, what will happen?
No, security deposit will come when? Let us say security deposit. Where is the security deposit?
Page 52, my lord.
Page 51, security deposit.
Yes. The successful tender shall furnish within 15 working days of the acceptance of his tender a security deposit for the due, proper and
So
complete
acceptance
discharge.
of standard is when?
When we have accepted his tender, when his price bid was lowest and he was successful. And
Okay,
then
understand. So
we have accepted it,
there
now
are
we
two
have-
things. One is that how tender is to be submitted. Okay. So once he is successful, one successful tenderer, within a time stipulated, he will have to give his signed documents. Then only question of security deposit will come. Your tender process is not yet complete.
Can it be taken up on next month? I will come prepared and all.
See,
Yes,
there are
got your lordship.
fine line.
I will read it again and
Again and
Yes, your
again.
lordship has point out one thing.
It is there is a fine line.
Yes. very
You
fine.
say that tender document. So on what basis you will give him an acceptance? You need his sign because if you read the other supporting documents scan uploaded, it should be clearly understood. Any attempt tender to change the format, all these are there. So therefore, subject to what you argue on next date, there is a process of tender. It's a stage by stage. Online,
Yeah, I've got your lordship point.
online, then hard copy. Online successful, but we'll verify. We'll not go by the online because only on uploaded. We want your certification that this is your signature along with attestation in every page. Then you give it to us. If we are satisfied, then we'll issue an acceptance letter. So all those things will come after acceptance. Prima facie, subject to what you say.
Here we have accepted and then asked.
You have reversed it. Yes, you can do the EMD. At this stage, you can forfeit the EMD. No doubt about that. For this violation, you can do EMD. Whether for this violation, you can still go ahead with the acceptance because this will create a doubt in the sanctity of tender of all future tender, whatever judgment we pass. If we say that there is no necessity, then there is scope of manipulations. This will question the sanctity of the tender. You will have to understand what is the purpose of giving. There is a fine line. When?
On next Monday.
Next Monday.
I have missed out to point out, my lord.
You make that point on next date. Yes.
Yes, because my lord, the period is over by now, my lord. 2 years period, my lord.
That is over, 12/5.
Which period?
that
For risk and
subsequent
cost
tenders.
factor, my lord. They impose only for a period of 2 years, my lord.
If you say infrastructure is close it, rest don't tell us.
No, that will remain, my lord.
That will remain. Risk and cost, what do you mean? Suppose they have
The difference
spent,
amount, because we
they have
quoted 100
spent,
rupees
suppose
now.
your quoted price was this, they accepted. Now, after the tender is
Again,
over,
then
they
we
have
will price
had
will
to
rise.
spend more. Then they will file a claim against you, risk and cost, that give us.
Right, my lord.
That is the risk and cost. That is, there is no bar in risk and that can be your best argument, and don't come to that argument that I am COVID and all that, we cannot consider.
My lord, because my lord, at that 11 point of time, my lord,
Forget about it.
there were concessions given to them, my lord.
We cannot,
MSMEs, my
Mr.
lord.
Saikia, you are a seasoned counsel. We cannot decide all these things in
No,
district
no,
court.
I am not arguing on the, for the purpose of.
The
my lord,
moment they
decision,
claim,
my lord.
you file a counter claim. That can be a different, but we want to know what is the object of a tender
Yes, my, exactly,
to
my
give
lord.
the hard copies with sign and attestation. Without that, can the tender further proceed? Can we interpret that? No, forget about all this, then they will do. So tomorrow, there may be a situation whereas a fraudulent tenderer is issued letter of acceptance by FCI.
That will not happen because it's e-procurement now.
We understand e-procurement.
Everything is online, my lord. Even that tender document cannot be opened on the, it will.
No, understand. That is not the issue. Issue is, you cannot control the, what document is uploaded.
Yes, exactly.
Can you control? He will give you a scan copy only, not the original. He will Xerox it on a paper, some manipulation, then he'll Xerox it and upload it. You don't have any scope to verify that document, or you need the original.
When it is a scan copy, you can see the original, the color.
No,
will be there.
no, what you can do is not the important thing. Sanctity of the tender. Then why should we give that condition to sign everything? You ought to have said that this will be treated as a
It's,
contract.
even-
In many railway contracts, it is written. That's why I'm asking that question, that it should be, the tender is a part of the contract and signing of the tender document amounts to signing of the contract.
Yes.
That is the purpose. So until and unless that is originally signed and given it to you, whether you can proceed further. That is the questions to be answered. Monday.
My partner.
Partner. Otherwise, we have spent so much of time.
Yes, ma'am.
Almost we are at the conclusion
Can it
stage.
be on 14th, my lord? Because 12, there were bond calls, my lord. Just for sake, my.
12 bond calls are there.
Yes, my lord.
14.
Bond calls, High Court will run.
Well, because transportation.
Arunachal lawyers, everybody is having big. He might have a problem.
Yes, once I was stuck up in my hotel room for 3 days.
So this on
14th, my lord.
14th?
My lord.
On 14th.
Obliged.
Hard in part, list this matter on 14th.